Welcome to the Appellate YouTube channel. Open mic number 159. This week we're going back in with Travis and Kel. They're going to do a part 3 for us for post-conviction process and answer some more questions to help us understand in a more layman's terms about what the courts look at, what they want. And, it's really complicated. And it's really the reason why I really wanted, when Kay asked me about this, I really wanted to do this because I think it's really important that people understand because our expectations don't always align with what the court's looking for at all. We look at it from a reasonable standpoint. They have a process that's different than, you know. Anyway, I apologize for my voice, but I got a pretty bad cold going on. I feel better than I did when I woke up. I felt pretty terrible, but I feel better. Voice sounds pretty terrible though. Anyway, but we'll get through it. Before we start, I want to let everyone say hello right quick. We'll greet everyone that's in the live chat, and I'm going to get going. So, Alice, you're up first. How we doing?
Hi everyone on panel. Hi everyone in chat. It's good to be here. Sorry to hear that you're no feeling well, Jack. I hope you feel better soon.
Thank you, Alice. I think Rhonda sent it to me through the internet. I'm not sure if she's pretty sick too. So, something's
Yeah,
going
I
on.
heard so. Yeah, sending lots of love and wishes to Rhonda. Hope she gets better soon.
Absolutely. Thank you, Alice. And then Cherie, how are you doing?
I'm doing well. Hi, everybody, and welcome to Open Mic.
Thank you, Cherie. And Sister Susan getting ready to go to a big music festival. I'm so jelly. I'm really jealous.
Yes, I am. Woohoo. Hi, everybody. Thanks for coming to listen. And Jack, I hope you feel better soon. Yeah, I remember that tickle you had yesterday in your throat. It's progressed a lot since then, it sounds like.
Oh, yeah.
Feel better, buddy. You too,
Yeah.
Rhonda. Get well.
Yeah, when I first woke up, my voice sounded really terrible, but it's improved a little bit. And then we got JD. Hey, thanks for coming, JD. How you doing?
Hi, everybody. Welcome to everybody in chat and looking forward to another informative evening.
Thank you, JD. And Kel, can't thank you enough for your work in the background, helping Travis get all this stuff done. It's a lot. It's complicated. And I'm glad, he's got somebody to help him that's intelligent that can go through this stuff. So how are you doing?
Good morning, everyone. I'm very well. It's very early in the morning, but it's great to be here.
Thanks, Kel. And then Travis, how you doing, sir?
I'm great. Thanks for asking. Thanks to everybody who's joined on the panel, and thanks to everybody who's joining us in chat. Thanks to Kelly for helping me get the questions organized. I had her go through the ones already been answered and consolidated the ones that still needed to be answered, and that's what we're going to start with after we say hello to everybody in chat. I assume that's what we're going to do. It's what we did the last two times. And then if there's time, we'll talk about one other concept, new evidence, and we'll just kind of see how it goes. I can stay around for a couple hours if that's what people want to do. But hello, everybody, and thanks for having me again.
Absolutely, Travis. We're really proud that that you would come and spend some time with us here. So try to explain the process. So and then Alice, can you say hello to everyone that's in the live chat that we've got so far?
Yeah, I sure can, Jack. Sorry, I was turning down my mobile there, or else we would have had an echo. Let's see here. JD's in chat and also on the panel. We've got our mod Jazz Naz. Hi, Jazz Naz. Good to see you. Kelly's in chat and on the panel as well. Nice to see you. Ronald D. Cass is with us. Hi, Ronald. Nice to see you. Our lovely mod, Dark Side of the Moon, is in chat as well. We've got Gloria. We've got your internet wifey, Jack. Nosy Wren. Hey, Nosy Wren. Nice to see you with us. We've got Anthony D who's with us. Hi, Anthony D. Nice to see you. We've got Angie Dickinson. We've got Nan's Life 7, Clive Coolidge, Emily Says, Charlotte Dowling. Oh, Dr. Silkman is in chat. Hi, Doc. Great to see you. It's early in the morning for you as well. Susan's in chat. We've got TTM Fangirl. We've got our friend Wooden Ballot Pete Moss is in chat. I'm sorry, Pete Moss. I just can't help myself when for doing that when I see you. We've got Rumour Has It. Nice to see you, Rumour. We've got Under Your Scars. TTM Fangirl. We have James Crane. Hi, Yoga. Nice to see you. We've got Behind the Magic. And Katie Did It has just sneaked in the bottom there. Hi, Katie Did It. Oh, and TJ Anderson, not only is a lurker, he's a sneaker in her as well.
He is. Alrighty, thank you, Alice. I will say that I've been talking to Dr. Silkman. He's got some stuff going on, but I think he's going to try to pop in when he gets that done if there's time. So thanks for coming. I know he's listening in. So anyway, all right. I don't really have any announcements today. Maybe something this coming week. We'll see. But Travis, are you ready for me to get the PowerPoint up on screen? What do you want to do first?
Well, first, let's talk about Labor Day just for a minute. Again, welcome everybody. Happy Labor Day weekend if you're in the United States. It's a celebration of the worker and the labor force in the United States and how it built America. The holidays evolved, been around since the late 1800s. Maybe Alice can tell us, they have a Labor Day equivalent in Scotland. What month and day is that in Scotland, Alice?
Me there, Travis. I don't know. I just go with the flow, and when we've got holidays, we take them, and when we've got days off, we take them.
God bless you. JD, when is it in the UK? In England, Wales, and North Ireland, what's your Labor Day? Catching everybody off guard.
Do you know? Do you know, Jay, when Labor Day is there?
I didn't think we had one, to be honest with you. We just
All
have
right.
all the bank holidays off, and we have Easter Sunday and Christmas and New Year.
Okay.
No, it's May Day.
It's May Day, is
So
it?
in
So
the
it's
UK
first
and
Monday in May.
Scotland, like most of Europe, it's May Day, May 1st is your Labor
Yeah.
Day.
That's
That's right. It's May Day. It's the bank holiday in the UK and coincides with International Workers' Day, also known as Labor Day. So, yep, it's May Day. See, that's just the holiday for us, Travis. When it comes around, it's the holiday.
And well, it's an important day. It kind of gets overlooked.
It sure is.
And then in Australia, it is not a federal holiday, meaning it doesn't apply to the whole nation on the same day. And I know Dr. Silkman didn't join us in chat because he knew I was going to put him on the spot again. But in Australia, it goes territory by territory. And I believe the territory he's in, their Labor Day is the first something in October. depending on what territory you're in, it can be beginning October, middle October, it can be in May, it's just all over the place. But apparently it's a bank and government holiday, so it says most businesses take off. And in Australia, the movement for a Labor Day came from what's known as the 40-hour demonstrations, where workers in Australia, again in the late 1800s, were demanding a 40-hour work week. And that's what the impetus was in the US, and International Labor Day, is all over a 40-hour work week. So, if y'all have a 40-hour work week or less, you can thank our forebears in whatever country you're in. That's all I'll say about Labor Day, unless anybody on the panel wanted to comment on that.
Yeah, not good. I think you covered it very well.
All right. If not, then Jack, you can put up the title slide and we'll go from there.
Okay, just 1 second. All righty, it's going to pop in there. You should be good to go, Travis, whenever you're ready.
Okay, so is it going to pop up in our screen, open mic voice? Is that where it was before?
YouTube.
Okay, all right, I got that up on another thing. Okay, sorry about that. Okay, there it is. Okay, well, again, thanks to Cal and the others who put this together. Let's go to the next slide.
Just before we actually get started, we've got a few that have joined us in chat. Just before we get into it, we've got Cher has joined us in chat. Hi, Cher. We've got Mark Kaz who's joined us in chat. Hi, Mark. Nice to see you. Andy B's joined us in chat. And it's TTM Fangirl's birthday week, so happy birthday when it comes. And we've got Sherry Lynn Pontillo, who's just sneaked in there. And Travis, the doc, said it's October 2nd in his state.
There you go.
Well, good. I'm glad, you knew Doc had to know about when the labor holiday was. I'm glad he knew it. Okay, I've got that slide up, Jack. Are we ready to go, or are you having any problems?
Well, it's not letting me progress. When I put it in read mode, PowerPoint's not letting me progress past the title screen for some reason. I don't know why that is, because it normally works just fine. I'll just leave it like this. It's fine. Everybody can still see it well.
If you need me to pull it up and share on mine like we did the last time, just let me know and we'll do that.
Okay. Yeah, we should be good this way.
Okay. So everyone was invited, and we got a lot of great questions going back before the first episode, just going back 3, 4, 5 weeks now, and we've been slowly getting through those, and we got through a lot at the end of part 2. So what I thought we would do is just go ahead and finish up the questions, and Kelly's got those all together for us, and then if people have questions as we progress, we can address those also.
Travis, I'll just ask everybody, if you have a question in the live chat, please put a Q in front of it, and that way one of the mods can see it, and Travis can get to it.
Excellent. So, I don't know, did you want to ask, did we introduce the panel? You did, right? Everybody said hello? We've already done that?
Yep.
Okay. Okay, so new witnesses. Kelly kind of grouped the questions together under an overriding topic, so we weren't all bouncing around, but we tend to bounce around a little bit anyway, but that's good. So the new witnesses, this is referring to Zellner's current 97406 motion, which is the third one, which was recently denied by the Circuit Court, and she has filed a notice of appeal to the Court of Appeals. And that 97406 motion, as everybody is aware, she attached an affidavit of a witness indicating that he tried to report information way back when at the time of the incident, never got followed up on, did an affidavit, and he claims to have seen a potential third-party defendant, third-party actor, pushing the RAV4 with another person, and then another affidavit sprung up, and so here's some questions that were generated from that. What are the general concerns of the credibility of these witnesses? Will you all collectively, the foul play team, your viewers, and discussing these? I haven't watched all of the episodes, but I've seen in Discord some lively debate about credibility, what the potential problems may be. I don't really have anything to add to that other than in terms of the 97406 process, you're presumed to get a evidentiary hearing where these credibility issues would be actually hammered out. You're presumed to be entitled to an evidentiary hearing unless the record conclusively shows you're not entitled to one. And that's what the Circuit Court held, that what was laid out with the affidavits and the other materials, that based on the record, that Stephen wasn't entitled to an evidentiary hearing, which I, strongly disagree with. And so that's kind of the answer to that. Credibility is always going to be an issue, and but the way you test that is you get the evidentiary hearing and you put those people on the stand under oath, and the other side gets to test what they're saying. Kathleen wouldn't be required to call the second witness. The state could, and so all of that's the way the system's designed, is explore those things under oath with cross-examination. Both sides get an opportunity, and then after all of the evidence comes in, the testimony, both sides argue, what they think the testimony means, and Kathleen would be arguing that the testimony shows that Stephen's entitled to a new trial, and then the other side could either argue, against it, or they could even agree. I doubt that they would agree, but that's the answer on the credibility question.
So basically, Travis, let's just pick Swiminski because he's right front and center. And I'm not saying anything good, bad, or indifferent. I'm just saying what we know. He's made statements in the past that don't really square with the statements he's made now. So that could come into play if there was a hearing, right? Is that kind of thing?
Yeah, absolutely. So I don't know if anybody watched the documentary about Eileen Wuornos. It is a famous British documentarian. I can't remember his name. Maybe JD knows, but he did an award-winning part one, and then he did a part two, which was Eileen's on death row. She's got a date coming up, and they're having motions to try and stop the execution. And during the part two documentary, which was several years after the first one, they called the documentarian, the filmmaker, the defense did, because he had captured on film and audio this attorney she had initially that pled her guilty to 3 or 4 of the alleged crimes, and just, how horrible. It wasn't as bad as Lynn's thing, nowhere near as bad, but she basically paid this guy some money, and he really didn't do anything. So
kind of threw her under the bus.
So they're on their way driving to the penitentiary in Florida to visit her, and he captures on film some, this attorney saying some things that, that showed how little or, nothing that he had done. And so then the state, on their cross-examination, they showed parts of the documentary, and they said, okay, you're driving to the penitentiary, what color shirt are you wearing? And well, it's white. And then they showed later on, and what color is that shirt? Well, it looks like blue. And they said, so you've spliced this thing together, right? And does it sound familiar? So you edited this thing together? And he said, well, I don't know. I wasn't prepared to talk about this, but I would have outtakes, all the raw footage, and I could tell you for sure. And he was very frustrated, but it's just an example of where, anything can be used to cross-examine somebody, and, they have the opportunity to explain it. And he's, could have said, well, I changed my shirt. It's Florida. That was July. You go through 3 shirts a day in Florida, which is true in July and August. Same in Houston. But that's just an example. But yeah, they would be able to use whatever sources they could to, cross-examine him on that.
Right. Okay.
Anybody else on the panel have any comments or on that one? If they do, great.
If I may.
Yeah.
Travis, just for confirmation, just for the viewers, because I see a lot of people get a little bit iffy about it. You said that you can use things. Does that go for clearly social media as well? Any kind of social media on their account that they have used and have put comments out there in regards to the case which differ from what they have now said in their affidavit?
Exactly.
Yeah, social media is fair game. You have to lay a foundation for it. So, but both sides now, in typical crime, both sides are immediately going to social media. And, criminal defendants are typically told to, deactivate their social media, even if there's nothing really to worry about. It's just kind of a standard thing. And, but both sides look at the social media of the main actors and then potential witnesses, and so they would be able to look at that. And then, you have to lay a foundation when doing cross-examination from something like that. So you have a social media account, you're on Facebook, this is your account, you see this posting here, you posted that. And then if they say, no, that's not me, that's not my account, that's pretty much the end of it. You can't waste the court's time on what's called a collateral matter. But if they're on, YouTube or something talking about it, all of that stuff is fair game. But yeah, social media, all of that would be up for grabs. And it could say, on this date you said this, right? And how do you, sometimes they'll let them explain how do you justify saying the light was red in your affidavit, but your social media right after the incident you said the light was green for this person. And they're given an opportunity to explain, but it's just like any other type of cross-examination. That would be fair game once you lay a foundation. And so if there's problems with that, you all are perfectly capable, more than capable, of researching and getting that together and laying it out. And so I really don't have much to add to that, and people can add their own explanations. But I'm sure both sides would try and talk to that person prior to the hearing, and then help with preparation. And this is what we were able to pull up. You're going to be probably asked about this, so you want to look at it. And so there's all kinds of twists and turns on that.
Excellent.
James Crane in chat says, I believe they used social media in the January 6th cases. Yes, they do. They did. It was a lot of videos and things like that was taken from social media. They asked people to send in videos and things like that anonymously that was took. And I think they also went through the people that was there who committed the insurrection, because to me that's what it was. They checked their social media posts and things like that as well. So social media is good for some things, but it's bad for others. And whatever you say on there can be used against you, free speech or no. Everybody's got free speech and everything like that, but your words can have consequences, so you want to have free speech, watch what you say, how you say it, and the way you say it.
Well said, Alice. Let me just point out, I was going to ask Doc this if he was in, but since he's not, say hello to our friend Mark Kaz, who's in chat. And, I noticed spells labor the UK, Australia way, puts the U in. Somehow we dropped the U in the US, but...
Yeah, you do it with the word colour as well, Travis.
Yeah, we're just lazy over here. We've got,
Hey, I did want to say hello to Andy B that's joined us in chat. How you doing, Andy?
Was there any more comments from the panel on number 1, or are we ready to go to number 2?
I think I'm ready.
I'm fine,
Uh,
Jack.
Thank you, Andy.
I'll probably drop out shortly because I'm quite tired after last night's like going to bed at 3
Bless you.
a.m. So
Already.
I'll be here for a short while. Thanks.
Sure. All right. I'm good. I'm good, Travis. I guess everybody else is good. If there's any more questions about number one, let's get it on, and otherwise, let's go to number two.
Okay, what doesn't warrant a hearing on these new witnesses? And I think what the question is asking is when would a evidentiary hearing not be warranted? And we kind of covered that in part 1 and 2, but just as a reminder, and we mentioned it as a lead-in in the previous question, if she files a 97406, it's presumed that she's entitled to an evidentiary hearing. There's one hoop she has to overcome initially, which is she has to show what the good reason is for not bringing the issue up in a prior 974-6 or the direct appeal. And in this particular instance, otherwise you're procedurally barred, there wasn't any claim that this particular issue was procedurally barred. I think that's because the Court of Appeals, pretty much laid out in footnotes that it was too late to be considered in the second 97406, but they gave her a clear green light to pursue it. They said you're going to have to show the good reason, but if you do, you can go forward. And they also put this other hook in about while the computer evidence may not be relevant for these motions that we're denying here, they very well may be relevant in the 97406 that you bring on the new witness. So she laid out what the good reason was, and it was a good reason. They weren't advised of any of this until much later on. The affidavit speaks for itself on what happened with that, and then it was confirmed that there's a call into dispatch where the witness tried to report something, but there was no follow-up. And so once you jump through those hoops, which she did, you're supposed to get a hearing unless the record conclusively establishes that you're not entitled to a hearing. There's no conceivable basis. And that's the way the circuit court went in denying the motion, which I've indicated I strongly disagree with. Let's see, anything else to add to that? I don't think so. Does the panel have any comments on that?
I don't. I mean, I agree with you. I think her reasons for denying it was pretty weak, but it is what it is, I guess. I just hope that the COA will take a different approach to it, and let's just clear the air, have the hearing, and flesh it out.
Yeah. Yep. Okay, let's go to the next slide. And
Okay, we've got a question in chat from Clive Coolidge. He says, question, a blunt-blooded object was found in the RAV4. A written affidavit by Mark Weigert. He did not sign it, but blunt-blooded object is missing. Can KZ include this in a new 97406?
those are, and Kelly, yeah, we are going to be getting to both those issues. And great questions, Clive, and they'll be coming up here shortly on both those issues.
Excellent.
All right, so go ahead. Anybody have anything else before we go on?
I don't.
Yeah,
No.
Travis, I just want to ask you because you feel like, the circuit court really failed with this. Do you feel like it's pretty likely that the appeal court will rule for an evidentiary hearing?
It's just too soon to say on this particular one until we see her brief and the state's response. But so what we have is the second 97406 and how the circuit court ruled on those 5 motions that the Court of Appeals ultimately affirmed on those 5 and set forth their basis. And so some may just look at that, well, they just denied everything. But there's some differences between this third 97406 and the second one. And the big differences are that on half the claims in the second one, half of those were procedurally barred. And so, we don't have that with this third one. The other half, they did rule on the merits, but some of those issues were extraordinarily weak. For example, the video reenactment, and there just wasn't enough basis to say that this is a truer account of what probably happened than something else. But that was kind of a throwaway. That's just kind of an example. So I would not instantly, if you're a supporter, look at the prior opinion of the Court of Appeals and instantly say, well, it's going to be the same thing all over. I think there's some differences. I'm optimistic. I think they've made the burden way too difficult on the direct connection part. And we talked about that last time, and we have a slide up. We're talking about with Denny, and Denny, you've got to lay out the 3-pronged test, which is motive, the third party's opportunity, and you can see them in the slide, and some evidence directly connecting the third party to the crime. Well, y'all remember in the decision of the circuit court with respect to these witnesses and whatnot, just these arguments about, well, so assuming it's true and this person's credible, because that's the way you have to look at it. She can't judge credibility at that stage. You got a person pushing the victim's car down the lane, and that person you tried to argue is one of several potential third-party witnesses that qualified under Denny. She's saying, well, you haven't established conclusively, and she keeps saying that over, and that's not the test. So, if the Court of Appeals, and like I said last time, I've found some recent Court of Appeals decisions where they granted evidentiary hearings or new trials. There's just a few of them, less than a handful, and maybe a part 4 will go through those because there's going to be a significant amount of time that elapses before we're going to hear from the Court of Appeals. Just the briefing process is, going to take several months. But so I can't really say, but I'm optimistic because there are distinct differences between this one and the prior one.
Travis, I have a question.
Yes.
I actually have two questions. I'm sorry, Susan. Go ahead.
I just wanted to ask if she has so much time to file this. Like,
yeah. So the process here is, and it's a good review. So last time I mentioned, it was significant. She had the choice to either file a motion for reconsideration with the circuit court to correct errors. You can point out, you put in your decision that, you said the light was green. You actually said the light was red. And so there's some strategic advantages to that. Sometimes, the court won't change its mind, but, will correct the record with it going up on appeal. She didn't even do that, even though you all found discrepancies and errors, and she just filed a notice of appeal. So it's out of the circuit court right now. And then the clerk of the Court of Appeals assigns two due dates. One is for the clerk of the circuit court to transmit the entire record up to the Court of Appeals. And I believe I can't remember what the deadlines are, but they're in the docket, and I want to say the beginning of October. And then the other is for the court reporter's transcripts. There's a deadline, but there's no transcripts here because there was no hearing. All the other transcripts have been prepared eons ago. And so her brief is initially due, what did I say, Jack, last time? Middle of October, unless there's an extension.
I think you said that the clerk at the appeals process has until like the 3rd or the 4th of October, and then Kathleen has like 30 days, I think is what you said. So it would be early November.
Yeah. So with mailing, and then of course she can ask the other side to agree to an agreed extension, and if they won't agree, she can file a motion for an extension. And an initial 30-day extension is almost an automatic. Not sure what else she has going on. Many times she has not needed an extension, and then other times she's asked for a 30-day extension. But
because she was involved in another court case or something, right?
Yeah, and they're pretty diligent in that office. There's some offices that they're asking for 2nd, 3rd, 4th, and the order comes, well, you've asked for another 30 days. We're going to give you 2 weeks, and then they put in there, this is the last extension we're going to grant, and, otherwise you're going to have to appear for an order to show cause. And they're not like that. I think at the most I recall, they've only needed one extension. So they're pretty good. Then the state's got whatever it is, 30 days to file a response, and then she's allowed 10 or 15 days, I can't remember what it is, to file a reply. Normally with the extensions and whatnot, it's typically been about a 6-month process once the briefing starts to happen. And then, of course, the Court of Appeals has however long they need to decide it. And these things have been running right about, a year. I haven't looked at it real closely, but it's going to be a year or longer before, there's going to be a decision.
Okay, I got a couple of
Wow.
questions for you that hopefully, one of them I think you can probably answer, but well, I don't know. So my first question is, let's just say take a hypothetical and the Court of Appeals orders a hearing. Can they put limitations on what that hearing can, basically do? Is that how they do it, or?
It varies, Jack, between, it goes Court of Appeals by Court of Appeals. It goes by case history. Sometimes, so sometimes the order will be, because again, it's a de novo review, right? We went over that last time,
Yep.
meaning the Court of Appeals looks at it new. They don't look at it to see whether the circuit court judge screwed up or didn't, or was, too tight-fisted or too loose about something. They look at it brand new, de novo, and make their own determination whether the record conclusively demonstrates she's not entitled to a hearing. And if they say we don't agree with the circuit court on that, we think that she is entitled to a hearing, and we return it back to the circuit court to proceed, consistent with this opinion. Other times, if the issues are convoluted, sometimes they may say she's entitled to a hearing at least on these things. Now, with this one, and it's an excellent question, I'm glad you brought it up, she's still trying to hook in on this Denny argument. She's trying to keep the computer stuff alive, right?
Right.
Remember
That's right.
seeing this stuff? So,
Yep.
They may put in there that, we think she's entitled to a hearing on this issue. And then the circuit court can judge the credibility and rule from there. And they may add, we also think the computer evidence is relevant, both on credibility and relevant on, whatever. Or, they may say, we don't think she's demonstrated this, and so it'll be limited to this. Hope that answers your question, but
it does. It does. So it could basically go kind of either way. It just really kind of depends.
Yeah, and so if the briefing, if the state's response is kind of like, their response is weak, maybe on the hearing, on the credibility of on Denny with the witness or witnesses, but they really dig in on the computer stuff, then the court maybe sometimes they reach compromise decisions and say, okay, we're going to give her a hearing on this, but we agree with the state that unless something differs by the time of the hearing, this stuff doesn't look relevant. So the way something's briefed can play a large part of it. The history of a particular case and issues can play a part in it. But yes, sometimes it's just they're entitled to a hearing, and we're sending it back for a hearing. Other times it's more detailed.
Gotcha. Okay, thank you very much. And now my second question, and I'm just throwing this out there because of the change in the Supreme Court of Wisconsin is now the Democrats have control, which is the first time it was a long time. I don't know how many years. Do you feel, this is a hypothetical again, that because of that there could be some different, does that stuff kind of filter down to the lower courts below the Supreme Court, or has no effect at all? What's your opinion?
It does filter down I don't know how long it's been we really try to not politicize courts,
Sure.
even the Supreme Court, but the reality is, if you have typically, in looking all through this case, whether it's the Seventh Circuit, how many were appointed by Republicans, or how many are identified as quote conservative unquote judges, how many are identified as quote liberal unquote or moderate, how many are Democratic appointed. So state judges, they're elected, and so a shift in that. Court of Appeals are bound, just like the Circuit Court of Appeals in the federal system are bound by Supreme Court precedent. And so it takes a while for that stuff to change, and same with state Supreme Courts. So, I don't know how long it's been democratically controlled, and I don't know,
Well,
if there's
actually
been any
it actually
decision.
happened. It actually happened in August, Travis. This lady judge got elected. She won the
Oh,
election, and so it was in August. She took the bench.
okay. Well, they've actually, on Strickland, they on ineffective assistance of no, I mean on Brady, Wisconsin issued. It's been a couple of 3 years now. They they have the most liberal, not the political sense, but most liberal interpretation of Brady, that you don't need to show a bad motive. The fact that the state didn't turn it over is all you need to look at, not that they had a bad intent in not turning it over. That is a much more liberal, pro-defendant point of view than even the Supreme Court has, and they were the first state to adopt that. So that was even when it was, a close court the other way. But it won't filter down, to answer your question directly, unless they end up deciding an issue that has a direct bearing on the case, on this case. So, if they had a decision on Denny, or a decision on the standard on how to review whether someone's entitled to an evidentiary hearing, that would filter down and be a part of it. But so unless that happens, they're stuck with the precedent that they already have.
Yeah, I'm like you, Travis. Thank you for answering that. That's kind of what I figured, but I'm like you. I don't want to involve politics at all, but and from a realist standpoint, it's there and it does affect these various cases. So
Well, and Jerry Buting in his book amplifies this, and I've been saying it for a long, long time, that you know local officials like district attorneys and sheriffs have tremendous political power, and you all are aware of this from this case. And unless you go out and vote, and local official elections are usually off years, meaning they're not part of the federal cycle. They're 2 years after, in between. The turnouts are very low. You might have 20-30% turnout, and so a very small percentage is determining who's going to be your sheriff and your district attorney. We've had tough on crime so to speak, for decades now in the United States. And so it's very, very important to vote in local elections, to see if, okay, that's fine to be tough on crime, but where are you at on a conviction integrity unit? Where are you at on, some of these other issues? And, kind of looking at what's the state innocence project, with WIP in Wisconsin, WIP, where are they on certain things? They try and stay out of politics because their boards are comprised of different folks for funding and whatnot, but you can kind of get a sense. Wisconsin has a state-run defender system, and they comment about decisions that come out. They comment on when courts of appeals get it right in their view, when they get it wrong, when the Supreme Court of Wisconsin gets it right and wrong. But, elections do matter. And so if, you don't get out and vote, there's, there's potential for abuse if you keep putting the same people back in over and over and over again.
Sure, absolutely. Totally agree with that. And again, I don't like bringing politics into a criminal or even a civil case, but again, I know it's there, even if it's not really talked about. It is part of it. So thank you very much for answering that for me, Travis.
Yep.
You're welcome.
We've got a couple of questions in chat, Travis. Another one is from Clive. He says, "Hello again, Travis." He says, "Kathleen Zellner did a video where she said to get around procedurally barred use estoppel. Can KZ use estoppel in court, or can she not use it at all?"
Thank you for that question. Judicial estoppel, remember that doctrine came up about they were working on more additional testing before Kathleen had filed a motion for additional scientific testing, and then she filed the second 97406 after she had dismissed Stevens' first one. And they were working out more testing that they had agreed on. And then before they filed a motion to extend or delay the decision, the judge ruled. And one of the things Kathleen argued was judicial estoppel, saying, look, here's emails. And then she put affidavits, which were uncontroverted by the state. State didn't disagree with her representations. And one of the representations was, she said, hey, do we need to notify the court? And then Fallon, I believe it was, came back and said, no, we'll get this worked out, and then we'll file the stipulation on testing with the request for the delay, and then they issued the thing. And the circuit court said, well, it's not up to them. They don't control my docket. They needed to let me know right away, and they didn't. And I was working on this, and I issued my decision. And so, no, I'm not going to reconsider. I'm not going to go back to square one. And then the Court of Appeals said, yeah, that's right. And, the only way we can disturb that is if it's an abuse of discretion, and under that standard, which is very tough to overcome, I said it doesn't qualify. Yeah, you should have done this and done that. And so I'm not aware of any similar issue that's involved here, and those issues are on this. When I say here on the third motion, I'm not aware of any estoppel type things, which is simply the state saying, well, yeah, let's do it this way, and you rely on it, and then the state tries to come back and say, well, you shouldn't have listened to us. And so no, she's not going to be able to bring that up again. Those issues have been ruled on, and they're done and over. And unless I'm missing something that's involved in the 97406, and it's been a long time since I read her brief. I didn't see anything about it in the decision, but Kelly, I don't know. Do you recall anything in Kathleen's brief in the beginning of the year that she had any arguments about judicial estoppel on this third motion?
She brings it up, but I haven't reread that one for a few weeks now. I can't remember the exact language she uses for it, but it wasn't something I can't remember her using it as the forefront of her argument or her motion, but it definitely did come up.
And maybe as part of the history of the case,
I think
she
so.
laid out in the facts that this is what happened. And so I don't think it's a main issue. I think she just laid out what the history was. And there's an important reason for doing that. It's basically like, you put us in this situation by not being flexible to grant us the motion to remand or motion for reconsideration. But I don't think it was a main issue. I think, she pointed out the court as part of the factual background. She mentioned that, and then she also mentioned that the Court of Appeals made it clear that we could proceed with this specific issue. Thanks for that, Cal. That refreshed my recollection. I do think she brought it up as a procedural history, but not as a main issue.
Okay, thanks for that, Travis. And Kimberly Neal has joined us in chat. Hi, Kimberly. Nice to see you. This might even be just a yes or no question. She says, hi all. To confirm, if or when the appellate court grants Stephen Avery an evidentiary hearing, would Judge Angie preside over the evidentiary hearing?
Yes. Her term expires this year. I didn't see anything where she announced she wasn't running anymore. I don't know if she drew an opponent. The primary over apparently in Wisconsin if they got a new Supreme Court judge in August. So, unless she's announced she's not going to run and somebody else takes over on January 2nd or the first business day, she'll be the one presiding over the evidentiary hearing. If a new judge comes in, it'll be that new judge. But I haven't seen anything that she's going anywhere. And welcome, Kelly, and thank you for the question.
Yep. All the questions I saw. Alice, you have anything else?
Go to the next slide.
No, I think we're... Oh no, Mark has had a question. He says, how can the state not allow further investigation if the bloody print not linked to Stephen and Brendan?
If the bloody what?
Print.
I think she's talking about on the
A23.
Yeah.
Yeah, we're going to go over all of that towards the end. We'll cover that.
Excellent.
Okay, thank you very much for answering those questions, Travis. And Kel, sorry, I didn't see that you had already answered that question from Kimberly, because I was halfway up the chat on the question and you'd answered it below. So, but I seen your asked and answered.
Okay.
I thought it was
I said,
appropriate to step in and object.
said, I misspoke. I said, thanks, Kelly. I meant thanks for the question, Kimberly. And we covered that. So we'll start with the question. What are the chances that witnesses are strong enough to allow a new trial, especially when these witnesses still don't exclude SA? And yeah, we have covered that. We can go to the next slide.
Okay.
Expecting that not answered yet, but I had legitimate tendencies, and this was just, we've already gone over this. This was just a reminder what she needs to show with these witnesses. 1, 2, and 3 are the 3 requirements, and we've already given examples. So we can go to the next one.
Okay. All right, it's up.
Okay, so we had some things on Brendan's case, and I'm just checking here real quick, make sure we've got the right. Yep, okay, you got the right one. Yeah, there's always, of course, understandably, no matter what it is, questions about how do things in Stephen's case impact Brendan's. So I wanted to cover a couple of these. Brendan's case, is there a path forward for him? Could a good defense attorney open the case back up with any of the evidence, or is it all barred since it wasn't used at trial? Brendan has not filed yet a 97406, so he's free when and if, and he has excellent attorneys, some of the best, but if they developed evidence that they can show a good reason why it wasn't brought up in his appeal, he can bring a 97406 with any issues as long as he has a good reason why it wasn't brought up on direct appeal, because he has no prior 97406. You know, he'd have to show he was unaware of it or it wasn't something he knew about at the time of the trial. It'd have to be new, but he'd be able to use anything and everything. If something in Stephen's case applied to his case, he would be able to bring it up if he could show he wasn't aware of it either. But the thing is that Brendan's case procedurally and issues-wise is dramatically different than Stephen's case in that as a legal matter, unfortunately, the courts ruled that his confession is completely and perfectly valid. And so it makes things much, much more difficult for him, unfortunately. You know, that's most likely why they went with the clemency pardon route after the Supreme Court of the United States denied his writ of cert. You know, it left the confession perfectly valid, so it's just it's much more difficult. With that confession, he has more hurdles to jump to show he's entitled to an evidentiary hearing. And it would essentially be someone totally doing a 180 on their testimony, and they're willing to give a affidavit, and they're a significant person, lead investigator, or somebody in law enforcement, or a credible actual perpetrator that got discovered. Either that or what I've termed smoking gun DNA, kind of like the DNA in Stevens' case, first wrongful conviction. But even that DNA, there was fingernail DNA, and they said, well, that doesn't mean Stephen wasn't the perpetrator. And then they got more DNA, and it showed who the real perpetrator was, and that finally got things reversed for him. But no, he has a path forward. It's just having the right evidence, the right issues, to where it's going to make a difference. And his attorneys aren't going to file something that's weak or marginal, because once you file something, you have to bring everything together. If you don't, you're procedurally barred. So part of it, they may have been waiting to see if any of the evidence that Stevens developed comes to fruition, but they've got different hurdles to get where they need to be, and it's a much more difficult case. Anybody on the panel have comments about that?
I think you pretty well got that one covered.
Okay, number 5. How can the community find out if Laura had tried to get the RAV since KZ can't? Really, you'd find out because there'd be a pleading under a different, it would be what Kathleen's original motion was when she came to into the case, a motion for additional testing, where she said she wanted to do certain types of DNA testing that had been developed since the time of the case. She said that they were willing to pay for the testing. State wouldn't have to come up with anything. And so you would know, because there would be a motion to do additional scientific testing, and it would list out the RAV, just like Zellner's asked to look at item FL, which they had examined some different things at DNA, and then they were in process of doing some things on the RAV. But I'm not aware that she's ever filed anything, but there would be an order, there would be a motion and an order in the file that she's done that. Now, again, testing the RAV probably isn't relevant to Brendan's case. They didn't, his DNA is not located in the RAV like Stevens is. It doesn't really bear on anything that relates to him, unless somebody on the panel has a different take on that. But you see what I'm saying? Obviously, KZ wanted to test the RAV in terms of trying to explain, if she could, an alternate way that the DNA, Stevens' DNA, ended up in the RAV than him actually physically touching it, him actively bleeding in the car. That's why she wanted to do DNA, and then possibly to look at some of these other areas. And Doc knows this stuff way better than I do, but maybe there was DNA that was looked at that didn't come back to anybody. I can't remember. I know there were print.
A23. A23.
A23 is what?
That's a blood stain on the back cargo door near the lock and the mechanism where you actually open the cargo door, and it didn't come.
Right.
It was a partial profile, but it was said that it didn't belong to Brendan Dassey or Stephen Avery. So
That's actually not correct. I've really looked into this. She never actually excluded even Avery or Dassey. What she said is, when she gets confronted about it, she says it was so impartial that she couldn't even get any kind of profile to go anyone. She had to testify and discredit KK because in his opening statement, he said that A23 had been scientifically connected, and all she could allude to was saying, no, I did not can confirm that it was Stephen Avery's. That is incorrect. So she was only saying it was incorrect to being part of what Ken Kratz said. But when you go and you read the actual report, she couldn't even determine whether it was female or male. And this is one of the things that they call KZ out on, because in 2017, she writes it as, and I quote, the male DNA of A23 excluded my client, and course of appeal was like another misrepresentation. That is not what the report says. That was not the basis of the conclusion with the results. The results couldn't even conclude if it was male or female. For all we know, it could be Teresa's blood. So that there's that A23, and that's what. And then you go back and you I think it was, remember Nadders, Justice Nadders or Nadders, apology if I got that wrong.
No, you got
he
it
did
right.
an interview with her, and he actually, a few people said, what about A23? And she said openly, I'm not interested in it. It's something that you can't go anywhere with it, because, and I think even Doc and I have alluded to before, A23, it was a presumptive test, and it was assumed to be blood, but the partial profile was so limited that she couldn't draw to any conclusions. So Silkman and I believe personally, and that's opinion based, that probably doesn't even exist anymore. Sherry Colhane probably got rid of that as a sample for all we know. It might not even be in the case anymore. Now, theoretically, she should have kept it because it's still a unmatched DNA profile that could later maybe be used in future, whatever, but there's no conclusiveness that it's even, one, still available, and two, that it was ever going to rule out Stephen or Brendan, because they couldn't even determine if it was male or female at the end.
Yeah, I just wonder.
Okay, so bringing this back to Brendan's thing. So he can't, since A23 was never used against him in his trial, I presume, he can't file a motion for additional testing to either, if it is still available and there's more of it to test, to retest A23, he can't bring a motion to go to the RAV and re-swab that to see if there's more. Even if, let's say, there was a new DNA test that would provide a significant probability that you could get a valid read. And it's not going to matter for him because that's not what got him convicted. And so, if it came out, oh yeah, okay, we're able to read this. It's not, we are able to read and we can exclude. It's not, sorry about that. It's not Brendan, it's not Stephen, and it's not Teresa. It's an unknown male, female, whatever. That doesn't help Brendan because that wasn't used against him in the case. The RAV had nothing to do with his case. Now, that may be significant for, sorry,
You're fine, Travis.
hang on. Oh, joy. Never, ever get a rat terrier.
Well, it's okay, Travis. I got a poodle that barks at nothing, so I mean he's pretty old, but
Sorry about that.
you're fine. You're fine.
So that's the. So in terms of Brendan, there are dramatic differences in the cases, but that's a good example of the question: Can Brendan's attorneys go and test the RAV? How do we know if they've tried to test the RAV? I think we've answered that. We'd be able to see in the court file that they pursued a motion for DNA testing, additional testing. That's not there, so it's pretty safe to say they haven't done that. And the reason why they haven't done it is the RAV, unless somebody can tell me, something I'm missing, but I don't believe the RAV came up in any way, shape, or form in Brendan's case.
I can't remember, but A23, 17 years later, and I would think that the DNA processes have been refined. I'd certainly be curious. I'm really surprised that Kathleen's not, but I would really be interested to see what they could find now versus back in 2006.
Yeah. So, and then, KZ's going to be probably precluded on that if that was something she was looking to follow up on that got either dismissed or ruled on the merits in the first one. So we can go to the next slide, see what
Yeah, it's that.
Can't even read that. Let me see if I can read it on my. Can't remember why I have that in there. Give me 1 second. I've got that up on mine, and I think I was just showing what she needs to show towards the bottom. And I can't remember what I'm quoting from here, if this is the decision of the circuit court or if I think this is the decision of the Court of Appeals denying the second one. Regarding potential use of this evidence, we're talking about the DVDs. In his Denny motion, Avery does not address the prejudice prong of the Strickland test, which in our view encompasses at least two key inquiries. To admit the evidence at trial that Dassey could have killed Halbach, Avery would have to provide some evidence at the pretrial Denny directly connecting Dassey to the crime. And then they repeat what the Denny standard is, the three-pronged test: motive, opportunity to commit the crime, some evidence directly connecting third party to the crime. I wanted to put that in there to show, again, if you're going for ineffective assistance of counsel, what are they trying to show? How are they trying to get through these keyholes, which you have to be conscious of when you're looking at it from the legal perspective. And those types of things don't apply to Brendan. And go to the next slide, and we start the questions on Denny.
Okay, it's up.
So number one, is it common to slightly misrepresent the details to favor the defense argument? As Kelly just mentioned, in the decision denying the second 97406 and giving a pathway to a third one, which is where we're at now in real time, the court stated several times that her firm had misrepresented the record, and they pointed it out. Now, there's a difference between remember Senator Monahan's famous quote, you're entitled to your own opinion, but you're not entitled to your own facts. It's perfectly okay to argue, if you have facts A through E, what those facts mean. And some of those could be against you. And so arguing, the ones that go against you a bit, why, they're inconsequential or not that important as compared to the positive facts, people are going to disagree what facts A through E might be. The state's obviously going to have a opposite view. There's no really slightly misrepresent. It's like being pregnant. You either are or not. I've looked at some of the things that they accused her of misrepresenting, and I went back. Kelly got them for me, going way back, and what she represented certain things to say, like an affidavit, didn't really say what she said. And so the Court of Appeals just came right out and mentioned 2, 3, maybe 4 instances. In one footnote, they said, in what is becoming a pattern, defense counsel is, misrepresented what her experts said, and so on. It's not very common. You don't want to be in that position. But yesterday, as I was preparing slides and whatnot, and it's kind of, we've talked about this in the last part, in a high-profile case, and there's, not one more high-profile than this, West Memphis 3, which I was peripherally on, way on the outside, involved with, there was a lot of, that was a high-profile case, but not nearly like this. It was a 3-part HBO series, but they kept there was a big supporter community, but the attorneys kept real quiet. This particular case, one of the defense firms has a more high-profile nature. They're in the era of social media, Twitter/X. Twitter and social media became big things in political campaigns. They've become bigger in social justice issues. So I'm not saying it's, good, bad, wrong. But then the other thing is, you kind of see the briefs. Some of the briefs you go back and read in hindsight, going way, way back, and they're written to the court in a legal sense, but there's a part of the briefs that, it's kind of being written for the press, which can be extremely important if you're trying to get a groundswell of movement on behalf of your client, that, okay, well, it's not really going in there for a legal purpose. It's going in there so that the media different social media groups, Redditors, they can look at the equitable balance. They can look at the justice of a situation. So I don't know if she put, it wasn't those kind of things. They were misrepresentations. So it's not very common to misrepresent. You don't really see that a lot in decisions, and it's not a good thing if the court's constantly, calling you out on it. Now, you all are perfectly capable of, researching this stuff, going back, pulling what they're referring to, and because I just did it in a very conclusory, quick fashion and just looked at a couple of things quickly, and it looked like she kind of went over the line a bit on what she was representing, or was just mistaken. But you all can draw your own conclusions on that. But it's not common. You can have situations where one judge can constantly say, "Oh, you're misrepresenting," and you're really not. You just have a difference of opinion on what the facts mean. But this is a 3-judge panel that did a per curiam opinion, meaning all agree with what's contained in it. And there's 3 or 4 instances where they point out misrepresentations, and that's very uncommon.
Travis, doesn't that also, I'm just guessing it does, but if a lawyer does that, doesn't that kind of hurt their credibility with the court?
Absolutely. Go to the next slide. And so this was an example of how, and Kelly dug this up for me, what she actually argued in her brief. And the state does not dispute that viewing violent pornography could establish motive for a murder. Rather, the state claims that the Dassey pornography of young females being tortured, mutilated, and otherwise abused is simply too mundane, too vanilla, too boring to predispose someone to commit a murder. The state opines as an expert, without having a real expert on violent pornography, that these searches of images for abused and deceased young females are simply too dull and generic for concern. And Kelly can comment more on this. She's much more up to speed on this stuff. But, there's a lot of disagreement, even in the community. You see it, where you see it in the community and different posts on Reddit and whatnot, is that it's images on the computer. And way back when I got access to the, however you pronounce his name, Zealy report, was able to go back, and they had the links, whatever you call that, and so you could go to the links, what the searches were, and they were searches on Yahoo or whatever. That's not going to get you to child porn, which at one point in time, maybe still, I don't know, there were, people were asserting their child porn on the computer. And, you go to those searches and it would pop up what it is. And Kel, maybe you can comment more on this, but so I can't remember some of this. I don't think she overstates this here in this particular quote. But I do remember in prior instances, there was some disagreement about, she had overstated in other things what the report said and why it was ineffective assistance of counsel to get their own forensic expert to do what they were going to do, that this one seems okay. They're talking about searches, but I think in other stuff, she went a little bit over the line in saying what was on the computer. And as I recall, it's something about these women bore a striking resemblance to
Teresa Holbach. Yeah.
Yeah, go ahead.
Yeah, so when you go back and you really, like Travis has just explained to everyone, I went back and as you guys know, I went in there with the mindset like I wanted to see it from the other side. So when I went in there, I wanted to see whether or not KZ did misrepresent, because that is the alleged opinion she kept getting against her. So I wanted to see, like Travis expressed just then, well, what are these alleged misrepresentations? So that's one of the things that they really highlight, and that they really went down on the Dassey computer. So the Dassey computer, obviously, Kathleen uses her experts a lot to opine the outcome of how her conclusions. And that was one of the things that they kept saying, your experts, one, cannot opine to the whereabouts of certain individuals, and they cannot opine to, their expertise does not match the qualifications to actually kind of say all these things in a nutshell. But more what Travis was just saying. She then went into more detail. She goes to the next level by saying that there's another concept to it as well, which I'll get to. But originally it was about Teresa Holbach, and it's striking a remarkable resemblance to her and the crime. And then you got to remember, everything that Kathleen has put in as a sealed exhibit, the Court of Appeal got to review that. And in their reply back, they clearly must have reviewed it, because they reference it and say, listen, everything that we have seen that is now on record that you have provided, they actually use the word, you have completely misrepresented it. Not only does it have no striking resemblance to Teresa Holbach, but it doesn't even mirror the crime at all. There is nothing that gives any indication that a crime, one, was going to be committed, two, the crime itself has any connecting factors, and three, all the things that are post the crime are exactly that. They're post the crime and does not fit in the category as motive, which is intent and such. So those are the little things. There's another concept that keeps coming up a lot, and more so in the community now, that adapted it, and Kathleen has referenced it, and more so in the latest one, and that is the C porn. And I'm saying that because I'm trying to make sure I don't get you guys in trouble. There is no definite proof that there is that content, and I have to express that as much as I can. There is no evidence that there is of searches of that nature. Even her own experts, in their own opinion, state that they assume it could be that because of the word basis of the searches, not based on the images, not based on anything that they reviewed, but based on the language that was used in the searches. The issue is those searches were put into Google. They have a pathway, the pathway of Google searches. And Google, even back in 2005, had their own filters. They had their own filters against pedophilia and all those dangerous sites which we all hear, that underground, the dark web kind of things. They do pull some pretty funny, pretty intense images and stuff, but they did have their own, boundaries as well. So even the own experts had to say that although what they have witnessed is they're only assuming that it could be that, not that it is. And that is something that the Courts of Appeal keep bringing up. You keep on relying on your experts who hasn't actually done a full review. They're relying on what you've told them, and now we have this misrepresentation. So it kind of went around and around in circle on that. The other thing is that I just want to, remind you all that, I know that a lot of people think that, the teen side of it and the language used, because we've got 13, we've got the number 13. We've even got the number 12 in there, some of the searches, which was put into Google. Listen, those on face value do, of course, they give you a red flag. You're like, ugh, that the search in itself is worrisome. But the images itself may not represent what the actual language that was put in is showing. And that's what they're saying. What you're trying to show us or tell us is there. We're not physically seeing it in what you have submitted to us. Kind of hope that helped. Travis, is that where you wanted me to go with that?
Yeah, and then I can answer Jack's question. So again, folks, we're just trying to show in the legal context and the adversarial process of 97406 motions, appellate practice, in the U.S. and, all the Commonwealth countries, UK, Australia, Canada, it's an adversarial system. And so counterpoint, it's chess, strategy, but that would impact, Jack, to answer your question directly, the credibility of the firm, the lawyer. And so what does that mean? It means, when the next go around, which is where we're at now, and this CD and the is still part of the case. She managed to hook that in, and the court in the opinion said these things may be relevant for motive on this particular third-party defendant. And so, you may be able to get into that, and, we're not going to prejudge it, but those things may be relevant. But you can be assured that whatever she writes in her brief to the Court of Appeals, they're going to know, as a matter of fact, if it were me and I went in their shoes, it takes up more space and use up a lot of words. But I think on real critical stuff, I don't think I would even try and summarize what the affidavit said. I think I would just quote the affidavit and then argue after that, and then they can't accuse you of misrepresenting. So see the difference in the prior thing, she would get facts and she'd summarize them, which that's typically how it's done because you only have a limited number of words. So you say, yeah, the affidavit of expert Smith, he says this. And she would summarize and she'd say, for example, only this particular third-party defendant, one of the brothers, only this particular one could have done these searches. Well, he didn't say that, like Kelly just alluded to. What he was provided information about who was at home during what hours, and so they pointed out, hey, that's a misrepresentation. He didn't opine. He didn't conclude that only third-party Denny suspect X could have done these searches. That was information that came from Zellner, which is an unsupported conclusion. It could have been him, but she hasn't excluded others. And so having the court call out prior, quote, misrepresentations, unquote, may impact the way they write their brief in the Court of Appeals, and they can, give specific, you have to reference the record anyway, but, she might want to do on the real critical arguments, she may want to just quote it and burn up the words, but just so it's clear. But no, it does have an impact on your credibility, and they're going to look at it anew, and she pretty much has to expect that they're going to have the clerks looking at all of the documents specifically, pull this out. I want to see what this expert she cites in the record. I want to see the affidavit. I want to look at it with my own eyes and see. So, yeah, it does impact your credibility, but there's ways to get around it and, be more careful.
So
And I just want to
basically,
quickly echo. Oh, sorry, Jax, if you want to go.
I was just going to say, so basically, this 97406 it's going through the process because of prior things that basically that they disagree with her and about the misrepresentations. They're probably going to scrutinize it a little harder. That's what I'm getting from what you're saying.
Yeah, I think they are now, but I don't think it's going to impact things one way or the other because the state, Kel, on the second 97406, what the court pointed out is misrepresentations, the 3 or 4 that there were. Did the state bring those up, all 4 of them, in their brief, or did the court bring up any on their own? I think the state pointed them all out, correct?
They did. The state did highlight them, and the courts of appeal then kind of adopted that train and jumped on and then added their own, because you got to remember and I just wanted to say before, to echo your point, you got to remember this decision made from the courts of appeal in terms of the misrepresentations and what the computer meant to them back then was being, used in the Brady aspect of it, not in the Denny side of it. So they, in fairness to Kathleen as well, they have now an opportunity to review it again and make their own corrections and go, you know what? Yes, I know we said back then that it was it didn't have a mirror image, and yes, that we found that there was a misrepresentation, but that was because you were using it that like the way you wrote it was in favor of the Brady, which didn't quite meet the standard. But now that you're representing it in the manner of a motive for the Denny, we now see that connection. So I agree with Travis. They will be more scrutinizing on the face value of it because, they have looked at all the exhibits allegedly and made an opinion based on those openly in their opinion. But they also now have the opportunity to look at it again in the new way that it's come forward in the Denny aspect and then kind of go, okay, let's make the basis of that. Does it match the criteria? And I think because we're in the Denny side of it, I know that Travis is like, we've all sat there and not laughed, but we all kind of scratch our heads with the way that, Ange has kind of gone on and how she's justified the denial with the direct connection. So what if Bobby was pushing the vehicle? And no, we're all like, what? At best, that's what an evidentiary hearing is for. But I think it's also fair that we really, and I think Travis will say it a lot better than I do, but something that we discuss. But you got to remember a Denny argument has 3 prongs, and all 3 prongs must be met. So even if you think that the direct connection, in a sense, is the weakest denial that she had, the problem is, for me, is I have to consider, is the other 2 prongs there or not, and would it matter? Because even if the courts of appeal says, you know what, okay, I agree. The decision that Ange made for the direct connection was pretty flippy floppy, but we agree with her on the other 2 prongs. Well, how can you get the Denny through when you need all 3? And Travis, if you want to elaborate more on that, fix up if I made any mistakes and how I kind of expressed that. But I always, the way that, and it's funny, apology, I got a frog in my throat. Kathleen, in one of her, in her motion, in her latest 974.06, she writes this extract of what you need to the standard of the Denny, and she says, you need A, B, C. The state take what Kathleen wrote and went, look, she did it herself. And then Ange did it again. She took what Kathleen said and said, look, you outlined what you knew you needed, but you didn't even meet it yourself. So I don't know why you're going to be shocked, basically. So it's little things like that. Trav, if you want to hit on that.
Yeah, and then I'll follow up, see what Dr. Silkman has some comments about A23, and so I don't know if Dr. Silkman's going to have the ability to join us at some point, but we're going to talk about
he sent me the
new evidence later on, but we'll circle back to that. He's much more qualified to talk about what the opinions were, and then need to hook it back into the appellate process. I don't think that A23 is going to fit into anything either for Brendan or so it may be something for another time, but I think it's relevant to discuss under new evidence. But I just wanted to see if I saw the comments, Dr. Silkman, and if you're coming back in live voice, going to wait for you to pop in before we talk about that more, because you're much more qualified to discuss it. But Jack, did you have anything else on this first Denny question on the misrepresentations?
No, just a comment, and then we can move on. And again, not being a lawyer and not really understanding the process, I did find it particularly odd that in June of 2006, about the middle of June, Kratz filed that third-party Denny stuff, but they were still investigating, and they continued to investigate even after the trial was over. So it's just I don't know, it just seems so he could play this. I know it's a chess game. He could play chess with Beauty and String and kind of lock them out. And the Denny hearing itself wasn't even done until January. It's crazy how that worked. Anyway, that's just a comment. You can comment on it if you wish.
Well, you're right. I can't remember. It was after something. I was after Ma'am 2 came out. Who wasn't it? Dietering that conducted at least a dozen interviews and looked at a lot of the issues that were raised in Ma'am 2. Wasn't that Dietering? You'll have it in the foul play library.
Yes.
And I just read it about a week ago. Was that Dietering that they had follow up?
That's right. He came back as a special, whatever, because he had been retired at that point, but he came back and did these interviews and so forth at that time.
And, a lot of it, they contradicted what Kathleen was saying on different points with different witnesses. But there was one issue they kept talking to people about, and I can't remember what it was, but he asked everybody the same thing. And, and I can't remember what it was. Was Stephen this way? And no, I never saw anything out of him that way, which, it confirmed one issue that she raised. Now, of course, a lot of the other ones, they dispelled with these interviews, but, they did a full-blown investigation on all of these things she raised, and, it was interesting. None of that stuff was done at the time. You're absolutely right. But this stuff gets complicated, and what Kelly is mentioning is, look, I don't think you really need to stretch to get to motive. I think she's got enough. You don't need to misrepresent in my opinion.
I
And
agree.
and then the thing about, okay, the direct connection, because I think the circuit court, in denying the third 97406, to me, it's like again, the presumption is you're entitled to an evidentiary hearing unless the record conclusively shows you're not entitled to it. And we pointed out the reason why that is that frivolous motion like Stephen's first one that he filed on his own without an attorney, court's not going to waste its time having a hearing on if you can't even raise an issue. And but unless it's that, you're supposed to get it. And the circuit court bent over backwards on things on all three of those factors, each of the prongs. Motive, well, you can't narrow this down. Direct connection, you haven't conclusively shown. And again, now she's making Stephen conclusively prove, without the benefit of calling witnesses to the stand, without the benefit of calling experts in pornography to the stand, without the benefit of subpoenaing documents. How can he possibly conclusively prove that that the fact that the third party suspect that they wanted to bring in since prior to trial is now seen pushing the vehicle? Now, again, she can't get into credibility, so she can't judge the strength of the affidavit. Can't say, well, how on earth can he, recall that it's the RAV and that it's this person pushing, and it's another person in the vehicle that they know. They just know, they don't know who it is. They just know it's not Stephen. I'm paraphrasing, and they can't judge credibility, and so. So again, what we're looking at is the circuit court just expecting too much. And what we're hoping is that the Court of Appeals puts a more realistic evaluation on it and doesn't just rubber stamp. They're not supposed to rubber stamp. It's supposed to be a de novo review. And, I'm hoping that they look at it more reasonably, because the Part 4, and we're going to need one, Part 4 will be some of the more recent decisions and the decisions where they ruled in favor of a defendant getting an evidentiary hearing, getting a new trial. There's only been 3 or 4 going back. I think I'm back 5-6 years. So it's not real hopeful, but there are cases, and there's parallels we can draw out of those. And I think Kathleen is going to, she's obviously going to be drawing parallels to those cases because they were successful. The different courts of appeals, even the Supreme Court of Wisconsin, said no, they're at least entitled to a hearing. So I think we've covered that on number 1. We can go to the next slide.
Yeah, just hearing you talk, I'll move to the next slide, but just hearing you talk about Judge Angie's, reasoning and so forth, it just seemed like the bar is set so high for Avery that there's just no way to get there. Just no way. The next slide's up.
Well, that's the way I was reading, and we've talked about that on this particular appeal, is that they agree and say, look, what you're requiring, do that. the fact that they've been able to come up with this witness and then confirm it with a phone call, and at least on its face, if he is credible at the evidentiary hearing, this is significant. It is at least worth exploration. And then we talked about last time that, okay, let's say technically it doesn't.
Oh, we lost
discretion.
We're losing you on audio.
Uh-oh. Can you hear me?
Yep, we can hear you now. Yep, you're good.
Okay. So we pointed out part 2 that even if technically you haven't met all the requirements, the circuit court the discretion to say, okay, well, you haven't lined this up perfectly. I'm going to go ahead and give you a hearing anyway. But to reverse the denial of that, the Court of Appeals, their hands are really tied. And we talked about, the of social media, kind of this comments on the quality of the rulings or the quality of the judge. The circuit court, even if they said, yeah, you haven't done it 100%, but this thing about this third-party suspect pushing the vehicle, I don't care. Let's at least get to the bottom of it. So I don't know if, can't remember what we talked about that on, in terms of style and, sometimes it's not good to try your case in social media because, a judge has the power, if you haven't done things perfectly, to cut you a break. Anybody have any questions about like that last comment? We talked about it at length last time.
I'm good, Travis.
Okay, and I'm okay now on audio?
Yeah, you're okay. Yep.
Okay, so this question, this third-party suspect, who we all know, has had his DNA taken and compared. He, like Brendan Dassey, doesn't have any forensic evidence against him. Does this have any effect against KZ last Denny argument? Well, it does in a way, in that judge in her decision, go to the next slide. And this goes back to, what Alice was very sincere. Go to prior slide. You went one too far.
Oh, there it is. Yep.
Okay, I'm waiting for it to, there's a little delay, come back up. But does this have any effect against KZ last Denny argument? No. This hasn't been an argument of the Court of Appeals, the Circuit Court, in the denial, but the Circuit Court judge in the decision denying the third motion, 97406 motion, brought up Brendan's confession. Hasn't been explained by KZ. It wasn't she didn't use that as a direct denial, but she said, given the situation in this case where you've got a confession by the co-defendant, you'd think you would have done a better job coming forward and conclusively showing this stuff mattered. And again, her saying you need to conclusively show motive, opportunity, direct connection, I think it's just way too high. It's an impossible task for any defendant to get the type of information and evidence to do what the circuit court said. But does it have any effect against KZ last Denny argument? The fact that there was no forensic evidence against Brendan, no forensic evidence against Bobby. Well, yeah, it does if you have the circuit court making these, these comments, not really argument or conclusions, but comments that Brendan confessed. Yeah, but I mean, if Zellner had, and I'm not even going to say his name, she had DNA of somebody living at Avery Salvage Yard, or somebody known. I mean, why, if you're the judge, would you even mention the Brendan's confession? I'm getting more like Alice. I'm getting more and more passionate about my comments about that comment. It doesn't really have any legal effect because it wasn't used to rule one way or the other on the motion, and so it's not going to impact the Court of Appeals. But it's the fact that there's no DNA or fingerprints or other forensic evidence tying a third-party suspect, whether it's Bobby or anybody else, to the RAV. But that's just the way it is. And so, but what has she come up with? She's found a witness who tried to report this to law enforcement, called, made an effort. Nobody followed up with him because, that wasn't their guy. It didn't get to KZ until just recently, and she tried to raise it while the second motion was pending. They said, no, we've already done most of our work. You can bring it in another motion, and that's where we are. So kind of a roundabout way to answer that question. Does anybody have any comments on that on the panel?
I'm good, Travis. I don't know
If
about
not,
anybody else.
we can go to the next.
Okay, I'll give that.
Yeah, I'm just, it bugs me, Travis, that Brendan's confession wasn't really used or anything like that at Stephen's trial. The motion was nothing to do with Brendan, but yet, suck at this, had the audacity to bring him up. And that, to me, that was trying to score cheap points in a sense and getting, oh, well, Brendan confessed, and I think that's what pissed me off about it.
I got
Is
you.
why is she bringing that in?
Yeah. So, again, and so I agree with that 100%. And then, but, what was first, the chicken or the egg? And this is just an example that there are pros and cons with having with doing a documentary, that a significant portion was about the lawyer in the appellate process, public comments about the rulings of the judge. I think so. I'm not trying to condone that type of comment. Has no place in the opinion, but I'm also of the view that some of the things that Kathleen has said, and it's to, it's obviously to, when you're making comments on social media, it's to stir support with a base, so to speak, a base of supporters, and making comments on a wide range of things. We've offered to Andy Colburn to come in and show us how he did this thing with the cabinet and the key. We've gotten no response. That's a paraphrase, but you all remember that tweet. And, so it, on the one hand, the pro is, you get comment and you show the supporters that things are being done and we're looking at this, but everything has pros and cons to it. So is that comment in there because of prior things that Zellner has said or done? I don't know, but and I said, the briefs kind of get written. They touch the legal points, but there's some filler in there that's you're hoping to catch the attention of the media because you want the media to report about these briefs, and media is not going to cover stuff unless there's some sizzle in there, some juice. And then, but you had the court in the Court of Appeals mention, we point this out because of the wide attention that this case has received, and hopefully this will inform, the public what the real facts are. I'm paraphrasing, but that was clearly for the media. So there's pros and cons on these different approaches. Sometimes that's all you're left with is just trying to get a groundswell of people to open their eyes and see the justice. But I think we've covered that. But I agree, Alice, and but if you're in a documentary or you're commenting on stuff, human nature kind of goes back and forth. And so, there's no legal answer on that. Okay, someone had a two-part question. This came up after, and Kel found it, and we added it in. And so let's talk about this. Recapping on the example of Martinez, Travis mentioned third-party Denny's like Martinez that would help in SA and BD cases. How can you achieve to get new evidence at this point? I'm not going to answer the Martinez part. That's going to be one of the cases in a part 4 that we'll talk about at whatever point to look at. There's some hope. There's some cases that I think we can all draw some hope and encouragement from the handful that have gone in defendants' favors, and we'll continue those. How can you achieve to get new evidence at this point? Well, that part, it's difficult. They've had billboards up with a reward, which has its own pros and cons when you have a reward. But I think they were looking for witnesses more to come in and say, hey, can't live with myself anymore. This is just wrong, and I'm going to point out what we did, or I think they're looking for LE or that type of a witness to come in and provide information. But what it's been is, fortunately, somebody was credible, at least on the issue of, I tried to report this at the time, but nobody followed up with me. But I think outside of what Zellner developed in the second motion, the scientific evidence, she was able to get the thing on the bones that different supporters developed. They figured out that the bones were returned to the funeral home. Rapid DNA testing, there have been a few things that got developed, but since then it's only been this one issue with the witnesses coming up. And so that she's doing what she can on terms of new evidence. That would be on factual witnesses. I don't know that you can do much more than offer a reward, and again, that's got some negative consequences to it. Fortunately, the main witness on this motion that's pending, he didn't make a claim for reward, apparently. You send out an investigator to follow up with other witnesses, track down leads, and then that's one side of it. And then the other side of it is to stay abreast of the most up-to-date modes of scientific testing, DNA testing, which she apparently has. She was well aware of the rapid DNA, and Dr. Silkman's commented about that. Apparently, Dr. Silkman would also like her to look at the MVAC system, but all you can do is stay abreast of the latest scientific methodology to see if it might lead you to something that was tested before and was inconclusive, that could be retested and come up with the result. But that's essentially all you can do at this point. Does anybody on the panel have a comment about that? And do you think I answered that part of the question? How can you achieve to get new evidence at this point? Or does anyone have another point of view on what she can do?
No,
Jackie?
you're the lawyer, Travis, so you know all the ins and outs. So that kind of thing, what she could bring in, what she couldn't bring in. So I think you've explained that one quite well.
Well, then, the others having groups like Foul Play, digging in and researching and open records and getting phone calls. And now a lot of it doesn't constitute new evidence. And we'll talk about that when we in part 4. But still, having group and they come up with something and they send it to KZ to evaluate. Unfortunately, a lot of it was already addressed at trial or was available at the time of trial, and so there wouldn't be a pathway on 97406. But, you never know. The thing with the return of the bones came up while it was pending, and I was with a group, where we developed that and determined that. I just made the assumption she already knew about it, but was wrong about that. But I discovered that on a fluke, a mistake. But so that would be the third way that you can achieve to get new evidence. A lot of it's not new evidence, but you never know what you can that might lead to new evidence. But those are the three ways. Does that mean if new DNA did get found and it was another Avery or Dassey, does it still hurt the boys because it does not eliminate them? Clarification, please. What this is discussing is on the Denny, the direct connection and the comments that Circuit Court made in denying the third motion that, this person pushing the car doesn't eliminate Brendan. It doesn't eliminate Avery. That's true according to, her standard, but I think she's put too strict of a standard on it. And so I think what the question about hurting is, so if you came up, let's take Bobby out of it, but let's say Barb's DNA is all over the RAV. Does it hurt? Well, yeah, it could hurt because now they, potentially bring her into the case. But, you just have to do what you have to do. And, if she had gotten the additional testing she wanted to do on the RAV, part of her thing she laid out is we're going to pay for all of it and we're going to give you the results. And that added credibility to her motion that we're so confident that Stephen's innocent, we're going to turn over the results. Doesn't matter, because we know it's not going to be Stephen. And we know it's not going to be Brendan. And, wherever the chips fall, we're going to go with that. And that's what you have to do. You represent one client at a time. You can't look at, well, how would this impact Stephen's brothers and sister? How would this impact his parents? How would this impact, you have one client. You've laid out the pros and cons to the client. Look, you need to be sure about this because if you're lying to me, all that's going to happen, and Zellner mentions this in MAM too, all that's going to happen is I'm going to I'm going to nail in the final nails in your coffin if you're not being honest. And he said, nope, not worried, go ahead. And so does it still hurt the boys because it does not eliminate them? It's just not a factor that we care about. We just represent our client and we do everything we possibly can to get them an evidentiary hearing or a new trial. When I say I mean the lawyers that handle that. I refer that out to specialists because it's a very complex area. But that in general is, when we represent a client in the criminal defense system, you have to represent that client only, and no matter how it may impact family, friends, etc. Does anybody have a comment on that before we go to the next one?
Specifically on that one, Travis, but we do have a question from Rumor Has It in chat. And I think she's asking because we were talking about the reward money and stuff. She says, what is the legal process with a whistleblower? You know, so if a whistleblower came forward, how do you know? I don't know if that's part of what you know, how that would work.
A lot of states, I don't know what Wisconsin's is, but if you see illegal conduct and report it, you are protected from retaliation. Jack, while I answer this, if you could skip the slides forward till you see question 4. It's going to be 2, maybe 3 down. And so if the person came forward and if they're not, whistleblower doesn't protect you if you're an active participant. So if there's somebody who came forward that said, incredible, I planted the blood and this is how I did it. You're not protected as a whistleblower. But if you observe that person or you have knowledge or information that shows this person planted the blood, reporting that, you would be protected under most whistleblower statutes. But the problem is who you really need to come forward is somebody that actually did it, and that doing that would be a violation of 2-3 crimes, probably felonies, and serious. But I hope that answered the question. Do you think I got it, Alice, or think I missed part of it?
Yeah, no, I think you got it. And we had another one just before we continue, and it's from JD, who's on panel. He says the DNA evidence that KZ has, can it be MFACT, and how can that get or add into the CODIS machine? Can that be introduced now or later?
Well, thank you for the question, JD. Jack, I don't know if you heard me, if you could go down while I answer this to the slide that's got Denny number 4. It's 2 or 3 down below where we're at now. I think, unfortunately, there's no path to do different testing on, by any means, on anything that's been DNA'd or, with the new NVAC system. And unless she filed a motion for additional scientific testing or filed a motion under the DNA statute. And so really what we would need to do is Dr. Silkman and I would review the statute, and I'd go over that with Dr. Silkman offline and see if we could figure out a way, under the requirements of the statute, would there be a way for her to file a motion and NVAC? And that's an excellent question. The short answer is it would have to be a new motion under the DNA testing statute, and we would have to see what kind of shot, and I'd need Dr. Silkman's input on that type of testing. If this stuff had been tested before, does that get us a shot under the statute?
I'm right here, Travis.
Oh, okay. So if you would like to do that, Dr. Silkman, I'd be happy to do that with you. I'll pull up the statute and get it. It's under 974. I think it's 07. But, you and I can put together a presentation on that if you want.
Yeah, that'd be awesome.
Thank you for that question, JD. Jack, next slide. Jack, are you there?
Sorry, Travis. Yeah, I'm here.
Go to number 4. If a hearing is granted, what advice would you give?
Which slide number is that, Travis?
14.
Oh, okay.
And then the slide says 4. If a hearing is granted, what advice would you give Bobby on the stand?
That's an interesting question.
There you go. So if I was representing, we'll take him out of the equation, a potential third-party suspect, I would sit down with them, and the first thing I would say is, if you're going to testify, be sure and tell the absolute truth, and then don't guess. If you don't remember, that's an appropriate response. And then he was re-interviewed by Dietering, and we have that interview, and he did a pretty good job of addressing the investigator. He just said, I don't remember, I don't, this is what I do remember. But again, the hypothetical client, I would evaluate and, might advise, if you are subpoenaed, and, Bobby may not be subpoenaed. If she gets an evidentiary hearing, he may or may not be part of the hearing. There's a bunch of strategy on that both ways, but assuming he was subpoenaed, then I would evaluate with the client the pros and cons of testifying, and then I'd make a recommendation on whether they should testify or assert their Fifth Amendment privilege. But tell the truth, don't guess. Remind them of their right not to testify. Anybody have any comments on that?
Can I just add a point there, Travis?
Hey, Doc.
Please.
Hey, Jack. Now, Bobby Dassey was asked fairly early on in the case. He was asked a direct question, and I believe the question is, he was asked, are your fingerprints or is your DNA going to be on the RAV? And he said no. Therefore, if he's completely innocent, and I actually do believe he's completely innocent, then none of his prints nor DNA should be present in the RAV4. Now, just going back to A23, we now have a potential excellent case that Kathleen Zellner can actually package together. And that will actually draw in, and I'd like to get your comment on this. And that comes about with the observation of Tom Sawinski, in which he said he saw two individuals pushing the RAV4 down Avery Road. Now, what is interesting is that A23 is a blood sample found in the back door of the RAV4. And I've actually got the testimony here in which Cherie Cohane excluded Stephen Avery from that sample. His DNA doesn't match. And it doesn't really matter whether you have a partial profile. If one allele is different to Stephen's profile, Brendan's profile, anybody's profile, you can exclude that person. Sure, it wasn't a perfect profile from A23, but it definitely excluded Stephen. There's no question about it. I've got the testimony right in front of me. So why can't Kathleen Zellner build up a case in which she was saying, hey, look, we've got evidence, or we've got an observation by Tom Sawinski that two individuals, you don't even have to mention Bobby Dassey, two individuals were seen pushing the victim's vehicle onto the property on November the 5th, the early morning of November the 5th. We have a third genomic DNA profile on the RAV as blood. That means whoever left their sample was bleeding. The state made the entire case against Stephen because he was bleeding and hence left his blood in the RAV4. You now have a genomic profile that is not Stephen's, and Culhane clearly states it in Stephen Avery's trial. Doesn't belong to him. Why can't Kathleen Zellner now present a case? Hey, we've got a witness who saw two individuals pushing the victim's vehicle. We have an unknown DNA sample on the back door of the victim's vehicle. Why can't she present that? And why can't Brendan Dassey's attorneys present that? Because that would potentially exclude Brendan. Thank you.
Okay, so there's a two-part answer. So if that may be her exact plan if she got an evidentiary hearing. So really, and we haven't seen an evidentiary hearing in this particular case, but having seen evidentiary hearings in many, many, many other post-conviction cases in Texas and around the country, you know, you present the testimony on that specific issue, and then you offer, when you're arguing, okay, this is why it deserves a new trial. And you say, we've got these witnesses, and then we also have the ability, even though it hasn't been done, we can do, you know, here's affidavits that show, and then exactly what you said, Dr. Silkman. We know that it's blood. We know that this would undermine the confidence of the verdict, that Stephen, you know, was the only person actively bleeding. And here's more forensic evidence we can obtain, or this is what we do have from the testimony of Culhane at trial. We know these things. And so you can hook it in that way, kind of as in the interest of justice, between the testimony of this witness seeing this, this is why, in the interest of justice, this deserves a new trial. So that's one avenue. Then, you know, why can't it be looked at independently? Why can't, can you tell me this, Dr. Silkman, does more testing need to be done on it? Or what the testing does show is enough if she was allowed to argue it?
The Cherie Culhane was incredibly deceptive, and that's why when I was listening to Kelly's explanation, I thought, she was very deceptive on the alleles that actually came up with A23. She never gave a firm answer. She only stated that it was a partial profile. So step number one is, why didn't Cherie Culhane publish her findings in a report and basically state, look, these are the alleles that I got. It clearly is not Stephen Avery, because the way it works, I mean, I've done this. This was part of my PhD. if you have a person's genomic DNA profile, if the unknown sample comes back with even one allele that's different, that excludes you. Do you understand? It's not you. The genomic profile is like a fingerprint. So you now have got an excellent opportunity whereby you have a witness that saw two people with their hands on the victim's vehicle. You now have Culhane admitting that A23, Stephen Avery was excluded from A23. So what I would do, Travis, is subpoena her laboratory workbooks and hence see what type of profile she obtained with A23. And if she still has the swabs, re-extract A23 and obtain a full genomic DNA profile and place it in CODIS, because you may not be aware, but with the series that we're doing at the moment, there's an unknown blood sample which now potentially could be in Mikkel's quarry, known as CX. It's a male, it's a full genomic profile. No one knows who that profile belongs to.
Should have been
So
ran through
I
CODIS.
believe,
Should have been ran through CODIS, I think.
yeah, to run it through CODIS to see who comes up with that profile, whether it's a convicted a criminal or whether it's a new finding. I believe that if Kathleen Zellner or the attorneys of Brendan can package it to say, hey, if my client was in that vehicle, you would find his DNA. That's why MVAC is so powerful, right? So hence, you can either rule in or rule out a certain individual. Now, if Stephen was never in that vehicle, if Brendan Dassey was never in that vehicle, their DNA would not be present. MVAC is very, very good at extracting cells, especially from the surface of a seat cover. So do I believe that further testing is needed? No question. The answer to the riddle is for her to obtain the RAV4 party over. Now, having said that, it could be party over for Stephen. He has to accept it, because if his DNA is on those seats, I'm not talking near where the blood is. I'm talking about using control samples away from where the blood is to prevent cross-contamination. If his DNA is found in that RAV, he's toast. He cannot explain it.
No.
So,
Trav, just before you get into that, I just want to elaborate more on what Dr. Silkman's saying. Yes, in the trial she does state, but the language used around it is they reference it. Again, Silkman said it. They very, very tricky. Her language, how she hits, how she came to the conclusion, and how she has to openly admit that it wasn't Stephen Avery, is just the way because it's open on the cross-examination through Beauty. He kind of gets it out of her, and then I don't even believe that direct touch it again. But one thing that I just want to let you know, just for that little bit more information before you make a conclusion, I've also found the laboratory document about A23. So it says that the chemical analysis of a reddish brown question stain or crust, they list off A2, A3, and so forth, and A23 is in that list. And then it says, please see laboratory report. So when you go down to that laboratory report and you keep reading, it says, a partial DNA profile were obtained for items A23 and DD1. Due to the limited genomic information, those profiles are insufficient for any interpretation. Then I went back to Brendan Dassey's trial. Now, they go a bit more deeper into A23 and Brendan. I know that there's a comparison, two different trials, but it gets brought up again. And in Brendan's trial, she elaborates more on that she could absolutely make no conclusion who it belonged to. She was unable to have any conclusiveness of it whatsoever. So that's the part of playing the game. In two different trials, she has to sit there and openly say, no, I didn't find Stephen Avery. But then she goes into Brendan's trial and she openly states that I couldn't even determine who, because it was so limited based on the report, I couldn't even draw a conclusion, period, on anything. And that's what I mean when I say, theoretically, Teresa Hallbuck is still on the table for being responsible for the blood of A23.
Well, but
Because genomically, she hasn't.
saying that she was misleading on that. So, and I don't have the technical terms right, but if it's not a mixture, it's from a single individual, and whatever the location is, XYZ, and that is either present or not present. And if Brenda, let's say on the A23, it's not present, and Brendan A23 is present, and Stephen, again, I'm mixing up the terms. The location, I'm going to call XYZ, and it's either present or not present. On the sample, on A23, it's not present, but on Stephen and Brendan, it is. What Dr. Silkman's saying is that's enough right there to exclude either of them. And what
Correct.
she was trying to do is confuse the jury into thinking, what she was saying is, I don't have enough to make a positive comparison, or whatever the magic words are.
Essentially, Travis, what she was trying to state was, according to the law, you need a 15 out of 15 loci match to be definitive. However, for exclusionary purposes, if even one allele
inclusion versus exclusion,
That's correct.
And she tried to be
she was very coy, and
sneaky about that.
I agree with what Kelly was saying. She was very, very coy. Now, what is remarkable is this.
But did Buting get that out on? Did Buting get that out in Stephen's trial?
It was in Stephen's trial, correct. I've got it right here where it says. Now she was asked about.
I can pop it back on screen, Doc.
Yeah, she was asked about A23, and Culhane said, based on my results, I didn't find Stephen Avery's DNA on that sample. And then Buting said, in fact, you found Mr. Avery's DNA nowhere on the rear of that vehicle at all, correct? Answer, correct. Which means that Culhane didn't have any forensic evidence to definitively say, I can't exclude Stephen. Do you notice the difference? She stated, I didn't find
I've seen you speak on this before, like 2-3 years ago. So
correct.
Let's go back to the question you asked, which is the most important. So what can be done with this now? And so unfortunately, because this was available at the quote, available, unquote, at the time of trial, available in the appeal, available in her motion for new scientific testing in the second 97406. And I take it, somebody confirm, in the second 97406, did she mention A24 or BZ in the second 97406, or just didn't bring it up at all?
You probably have to get Kelly. Kelly's more versed with the official document.
So we need to do a presentation on that. But so we saw on a number of things that she wanted to test, and also the bones. We saw on the second one that the circuit court said, well, you shouldn't have filed, if you had more testing to do, you all remember this, and I'm paraphrasing, if you all had more testing to do, you should have never filed your motion. And then they went back and forth on that, and then it went up to the Court of Appeals, and then unfortunately the Court of Appeals said, we don't have any basis to overturn turn that. So yeah, you're stuck. And so this dovetails into what I asked if you wanted to do a joint presentation on the other issue. This fits into it. And so does she have a grounds for filing a motion for DNA testing under Chapter 974, whatever the 0.07, whatever it is? And this would be part of that. And then we'd look at, is she precluded because it should have been brought up in the second one, and Stephen's just a victim of the procedure and trappings of the court? Or, you know, are there some things that could be done with a new process under their DNA statute? But that's the way we would need to analyze it.
Doc, do you remember if Kathleen ever brought up A13A, the memory card?
Now that I'm not sure, because I know that Culhane did not extract genomic DNA from quite a few items.
Right.
And I'm wondering,
she had it ready to go,
yeah,
but she didn't do anything.
did not test it. And I'm wondering whether she can actually claim some type of incompetence by Cherie Culhane by not re-extracting A23. Because if you're doing due diligence and you've got potentially a third genomic DNA profile on the victim's vehicle as blood, one would expect the laboratory technician who is not biased to say, hey, look, I'll do another re-extraction from the swab and obtain a full genomic profile, because it is the victim's vehicle. I think we all agree it is the victim's vehicle. You have a third genomic DNA profile on the victim's vehicle. When you factor in Tom Sawinski, what he said, that he saw two people, and I'm not mentioning Bobby Dassey, he saw two people with their hands on the victim's vehicle. I do believe that now strengthens Kathleen Zellner's position by saying, hey, I want A23 retested, please. I think that's fair.
So you got to be careful, and that's why we would do a separate presentation on that. So, for example, arguing that Cherie Culhane was incompetent, and let's say everybody in the scientific community, the forensic community, would agree with that statement. Let's just assume that, okay? You got to be a little bit clever, not deceptive, but clever and imaginative with the way you argue these things, because assuming that's true, that should have been pointed out by KZ's DNA expert she had for the second 97406, and then it would be procedurally barred. But these true geniuses like Dennis Reardon in post-conviction, they think of very imaginative ways that have legal credibility of being able to argue the exact same piece of evidence, how it applies under a different standard and under a different pathway. A very generalized example is, okay, it may not fit under Denny, it may not fit under IAC, it may not fit under Brady, but it fits under in the interest of justice. Now, KZ hasn't had a lot of luck with that, unfortunately, but the Wisconsin Supreme Court, in some cases, and we'll talk about this in another part, has followed that. But the way we're talking about it now, wouldn't get us there because she would have had the opportunity. But, I think if we all sat down and looked at the statute and looked at some examples of how these things can be argued differently, especially, by someone who knows a whole lot more about this process than I do, that may be a possibility. But I just wanted to point out that, if you just that quick example, Sherry was incompetent, grossly negligent, both in her opinion, which that was kind of an issue in a case I was involved with. I'm in Texas, but I was helping out a wrongful conviction in Oklahoma on the civil case. That was one of the issues. What the DNA expert testified to at trial was misleading and deceptive. And the problem is if that should have been apparent at the time of the second 97406, we got this procedural bar thing. But there is a DNA testing statute in Wisconsin, and I think it would be a great presentation to look at that statute, and if there's a path forward on being able to demand retesting. 3 or 4 different people asked or touched on exactly what you're saying, probably from your presentations of foul play and the talks you've done, Dr. Silkman, but I've heard you speak on BZ and the A24, if I hope I have the number right.
A23.
Going back, I want to say 3-4 years.
Yes, I've done presentations. I had really good discussions with Eric Cozy as well.
Yeah, but it's gelling in my, it's just now starting to gel more and more in my, we go to law school because we don't have science or math. So
yes.
I think that would be an excellent presentation, but I have a question surrounding that, and you can answer it briefly. Let's just say that Kathleen chose that path for DNA retesting because of whatever under the statute. Did she ask for A23, A13A, and some of these other ones? Just basically several DNA samples that really weren't tested at all, or does it have to be because they weren't included in the trial? They weren't included in the trial. A23 was.
Yeah, well, we don't know until we look at the statute, and especially in Wisconsin, because remember we had this evidence preservation statute.
Yeah.
That I thought it was clear as day. You got to preserve this stuff until the prisoner dies, the prisoner is released, or you notify the prisoner and they don't object. And then what was the ruling on that? They said, well, there's no ruling, there's no remedy, no harm, no foul. You haven't shown prejudice. You haven't shown this. You haven't shown that. And, I don't even know if they admitted it was a violation. I don't even think they.
No, they called it inexplicable.
That'd be a great song, wouldn't it?
Just so we can get it.
We need to talk to Stacy. Sorry, Cal, go ahead.
I was just going to say, just so I've just done a little bit of background research here, just to give a little bit of a foundation of the timeline of A23, though, just for purposes of where it's come up and whether KZ used it in terms of what Travis was saying. Has she, in a sense, wavered a right because she's had they might say you've had all these opportunities, blah, blah, blah. But so in 2016, when she requested all those numerous swabs and all the testing, she didn't include A23. So back when she asked for all testing to be done, A23 wasn't a part of it. Then in July 2017, she put out a A23 Stephen Avery proof of guilt challenge. That was more to the media. I think that was a tweet kind of situation. That was more of a explain how it could be Brendan, blah, 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 or Stephen. And then in September 2017, she actually that's when she was having the meeting again with something to do with the when she was going on about the RAV4, she wanted to get her experts, Carl and Christopher, to do some forensic testing on the RAV, especially the cargo area. She writes in a reference to the RAV4, and item A23 is kind of comes into it. She says it's actually vital as it will exclude Avery's involvement. But in October of 2017, the circuit court shut that down. Remember, she ruled, and then she lost any further testing that she had made plans with the state. Then in 2019, Zellner wrote in her brief of the Courts of Appeal about A23, and she references it being a male and it didn't match Avery, and then they denied it. The Courts of Appeal were like, nope.
Now, that wasn't one of the issues that they said she misrepresented, did it? Was it? There was something mentioned in it. I think it was something to do with how she says it was male, and they're like, I have to reread it again. This is the bit where they say something about it. She's stating it was male, and they're like, it wasn't even conclusive that it was any kind of profile. You're making an assumption yet again. And basically she got denied it. So it has A23 has circuited through the courts throughout the years and has been heard. So thank you for detailing that. So because I don't know how you all collaborate on the other things that you collaborate on, like reading with the crew. I hope I have the title right. That was last night that I always try and watch when I can. But, however y'all want to do, but clearly it's going to require at least three of us, for sure, Dr. Silkman, Cal, to, get us all the history. And then, if you want me to lead it up, and I'll schedule time with Dr. Silkman and Cal, or Dr. Silkman likes to lead these because of his schedule, or I'm happy to do it whichever way. And whoever else, you bring into these things, I'm happy to work with 3 or 30 of you, but it's obviously going to take a team effort, which from what I've seen on Foul Play, you'll have accomplished amazing things as a team, but clearly it's going to require a collaborative effort. And, we should work on that and do a present. We're going to have plenty of time while this appeal works its way through, but I think that would be great if we tried to tackle that and answer some of this, because you'll develop theories that have factual basis. Last night was a perfect, let's see, was it Friday or Saturday? Anyway, reading with the crew, the factual basis on these things, and okay, well, why can't this be brought up, and or can it, but the stuff with DNA, and a lot of people are interested in this, why can't this be run through CODIS? That was another piece of evidence, and can Kathleen run it through CODIS? This goes back years. I was being asked, and no, a layperson cannot submit something and have it. It's got to be law enforcement, and pretty much, need to get if law enforcement won't do it voluntarily, then you need to get a district court or circuit court to order the LE to have that done. But I think it would be a great topic, but it's something we're going to have to dig into further without just speculating.
And for sure. And it will take a long time to do, but I think that's a very important exercise to do, and I'm more than happy to help out. But just a quick point, if Kathleen Zellner stated that A23 was from a male, that means that Cherie Cohane would have had to have the result from the amelogenin marker, which is very interesting because that's the sex determining marker. So if that came up with an X and a Y, that meant that A23 was from an unknown male. If it came up with XX, that's from a female, which is very interesting because that's precisely what she got when she tested item BZ, was a partial profile, but the amelogenin marker proved that item BZ was from a female, because the amelogenin marker of XXX came up. So does Kathleen Zellner actually know the partial profile of A23? That'll really be incredible. I would love to see what results were obtained, because we have the DNA results from the Dasseys and the Averys, and we can easily include or exclude any one of them.
It is interesting that she didn't publish her results, Doc. I didn't even think about that.
Yeah, Colhane never published her results.
Yeah. Just with still being on the A23 subject that we're on, with Kel talking about when A23 was brought up by KZ and the motions and things like that. Well, what you've got to remember at that precise point, A23 didn't mean too much, but like Susan said in chat, she didn't have the affidavit of Sawinski at that time, because that didn't come until 2021, which he says he saw two people pushing the RAV up Avery Road. So in my opinion, and I think in Susan's opinion in that as well, that brings A23 back into being suspicious, because we've now got somebody who is saying that they seen people pushing the RAV after Teresa was supposed to have been murdered. So that print could or should be re-looked at.
Yeah, I agree. And it's not like, as I stated before, when I did my MVAC presentation, you don't know what those results will be. However, A23 is a forensic sample obtained by the crime lab specialist Cherie Colhane. She obtained a partial profile. Why not re-extract it and obtain a full profile? Unfortunately, I have to agree with Kelly. I believe that Cherie Colhane probably tossed out the swabs of A23.
Just out of curiosity, Dr. Silkman, because I'm just reading what she says in Brendan Dassey's trial when she goes on to A23. She's talking about, I'm going to read it to you just so I don't paraphrase it. We get exactly accurate. That way you can make a better assumption or opinion. It goes on about, I don't want to read it all because we all know the backstory of it, but they're going on about how there is instances where she's had partial things, like when she's matched Stephen before, Teresa before, where there's like 7 loci, but the standard was like 15 or such and such. So they're saying, she goes, that's basically a partial. That is what we classify as a partial, but I was still able to determine from that baseline, because like you said, you can kind of still make sure that as long as the ones that you do have a matching, or whether it just excludes. So she's going on about that. But then they ask her this really specific question. They go to her, in regards to A23, you question, and you were able to come up with only a partial profile. But here what you're saying it was only probably more like only 3 characteristics. Answer, yes, that's right. Question, so because it was so little, you weren't able to come up with something that you can even give a partial profile to? Answer, correct.
Yeah, but the obvious problem of that is this: she never presented any data. Right. So
my thing is though, is the 3 characteristics, is that she referring to that as the loci side of it?
Yeah.
Is she basically saying I only was able to get 3 loci out of this partial compared to the other things where my other partials were up to 7? And they're saying, so it was so little, you can't even make a determination. So my question basically is the 3 characteristics, is that referred to the loci, correct?
Yeah, normally it's referred to loci. So potentially,
loci, my apology.
Yeah, so potentially you can have, now wait for it, 6 alleles. 6. And because she said it was a partial profile, she could have obtained a reading from other loci, but only got one allele coming up. Do you understand? Instead of getting 2 alleles, she only may have gotten 1. Because she never placed the profile in court up on the screen, it meant that we had no way to determine the veracity of her findings. Do you understand? Whereas with item BZ, she put up the 7 loci that came up and the associated alleles. We never got a chance to look at A23, which is very interesting. So remember, you know, when you said about the 3, that came out of the mouth of the attorney, didn't come out of Culhane's mouth. So he just came up with a number and she just agreed. That's not a conclusive answer, right? So what clearly we need to do is subpoena her books and actually get the electrospherogram, the result straight from the computer. That will tell you the allelic peaks and potential profile of A23, because these guys are very clever. If a peak, when you read the sample, if it falls below a threshold, they say it's inconclusive. They might have got a whole profile, but it wasn't that good. Furthermore, the electrospherogram will tell you whether it's a pure sample or there are multiple DNA samples in that profile. Culhane was very, very cautious what she said about A23. And let me tell you right now, guys, Culhane never would have mentioned A23, but Kratz made an error in his opening statement. Thank you.
All right. Travis may have stepped away.
Okay, let's see, where are we at? Let's go down to
114.
Skip to 19.
Okay.
Miscellaneous number 1.
Yep.
Well, you're getting that, Jack. Susan in chat, because she had to leave because her headphones died, so she's listening and putting mentions in chat. She says, just the fact that we now have someone saying they saw 2 people pushing the RAV, which is new evidence, seems to me A23 should be able to be tested for an evidentiary hearing. Yeah, I agree with that as well. Let's see if there's anything. Anthony Hills has got a question. He says, is Stephen a free man if the RAV is gone?
That's a great question. But to me, if they'll give away bones to the family, they'll do anything. That's just in my opinion.
Yeah, mine too, Jack. Mine too. We'll be lucky if that RAV's even there.
It may be, but
like Doc says, or whoever it was a Kel that said about Culhane no even having A23 now. I think that could be a huge possibility, because when that came up years ago, they could have got rid of it. They could have destroyed it. And I wouldn't put it past them. I certainly would not put it past them. Because the same things happened in Luke's case. They did the documentary in the beginning of 2021, I think April, May, something like that, 2021. And by the November of 2021, they were destroying evidence that shouldn't have been destroyed.
it's crazy.
So if it can happen here, it can happen fucking anywhere.
Yep.
Because I used to think our justice system was good and just and all the rest of it. I mean, I knew of a few wrongful convictions that happened, you know, like the Birmingham 6, the Guildford 4. There was 2 Joe Steele and TC Campbell. They were all wrongful convictions, but they were like in the the 90s and things like that, and I thought we'd learnt our lessons, you know. But obviously we have not. Big time have not. So we've got dirty fucking cops here, as well as yous have got dirty cops in the States and all.
Yep.
Also on that, Buting asked Sheree Cohane during Stephen's trial, did you find any of Brendan Dassey's DNA anywhere? Cohane said, nope.
There you
go. James Crane says the problem is getting the RAV. If what the doc says is true, the state will never turn it over because they know the truth. Yep, I completely agree with that and all. I think KZ is going to have to fight tooth and nail to get that RAV, if it's still there.
If I could just answer Anthony Hill's question. This is and I think Kelly is aware of it too. This is a serious problem that happened in one of our laboratories here in Queensland, in Australia, whereby that if the DNA that they extracted was not of a high enough quantity, they said no DNA extracted. Can you believe that? So even though the DNA was perfectly enough to do a PCR, according to their laboratory manual, if it wasn't of a certain amount, they regarded it as no DNA in that sample. And we're talking about rape cases, murder cases. They're now all up in the air because of that rule that they used in that Queensland laboratory. I don't know if Kelly would like to comment, but it's an absolute disgrace.
Before Kelly comments, can I ask, this came up last time, but in Australia, are your forensic laboratories run by law enforcement, or are they a separate entity and accreditation separate from law enforcement?
Normally they're state run, but I must admit, Travis, I haven't read all of the forensic lab requirements. I'm not sure whether Kelly knows. It's something I haven't delved into. So I do apologize, but I can definitely check up online later on. I know that in Wisconsin, they're part of the state.
Well, yeah. Well, so for example, Colorado, the labs are separate from law enforcement. They're run by the Department of Weights and Measures. In Texas, they're run by DPS, which is Department of Public Services, which is a law enforcement organization. Texas Rangers are part of DPS. The troopers are part of DPS. So it's effectively run by DPS. There's a lab director over all of the labs. There's constant problems with the labs, even though there's a national accreditation. ACLEA does most of forensic laboratory accreditation in the U.S., but some states have said, it's not enough. We don't feel comfortable. It's not enough that they're accredited because the culture, when it's under law enforcement, there's still, problems. And so it goes back to the note, the handwritten telephone note Sherry filled out. Need to put him in the house or the garage or whatever it was. You know what I'm talking about. But
yes, I do. Fassbender.
So that's part of culture, that the lab is part of the team, right? They're
Correct.
Not supposed to be. And so some countries and states, they set it up separately. And there's still problems. You got to be diligent, because those people, even if it's under a separate agency, they're less susceptible to being given, could be considered an order. Put them in the trailer or the garage. But they still interface with law enforcement on such a constant basis. They tend to align with them. And so you need to be, constantly vigilant with these labs. But I was just curious. Kelly, I don't know if you had a comment on the Queensland situation Dr. Silkman talked about before my question or not.
No. I wasn't gonna say anything about the Queensland situation. I'm aware of it, but I don't really know enough on it. As for the labs here, I'll be honest with you, I haven't really looked on it this side either. I just remember that, and funny enough, Investigator T, I'll never forget it when he and we still talk every day, but when we were talking this case, and one of the first things when he started getting into this case, I remember his reference to was that footnote, or that note from Fassbender to Sherry Colhane, and he's like, can you believe they said put her in the garage or the trailer or whatever it was? And I was like, yeah, I know. And he goes, and I remember him actually saying to me, it's such a big no-no when we drop off things and it leaves our chain of custody. The crime lab and us, we're not even meant to talk. Like it's a business. There should be no communication. There is no, can you help me here? They're meant to be getting, he said a word for it. I think, Dr. Silkman, you've said it before as well. It's like blind testing or whatever. So they don't even know what came from what came from where. They're just going in there and testing it, and it is state run is the way he made me believe, but it's its own independency. So because they don't know where the sources have come from, it gives them that security of not having that persuasion one way or the other, even though that they are funded or ran by certain states. But yeah, so that's funny that you should bring that up, because it's one of the areas that he always could never get his head around, because he's like, once we go to the crime lab and we drop off what we have to do, there is no communication from that moment on. Nothing. Zilch. You sign it out and you walk away and you don't speak to them basically again, unless you have to go back and give them more stuff.
It should be material in, assigned a number, and then results out, assigned a number. Double blind.
Correct.
Yeah. So, Doc, Anthony Hills in chat asks, are you using Queensland Lab thresholds?
Yep.
But then he does ask, we need an international standard, right, Doc? And I'd like to hear your comments on that.
Well,
because
I mean, the Buting has put forward a lot of proposal about fair forensic testing. And in this particular case, there was no fair forensic testing, because when the co-lead investigator can casually ring up the lead laboratory tech, Sheree Colhane, and make a request like that, that's a real worry. And you see, Sheree Colhane knew exactly where the swabs had come from. She did all the swabbing herself. She did all the documenting herself. She actually held forensic evidence at her bench. She admitted, instead of putting the forensic evidence in a special locker cupboard, she actually had it next to her bench, which is a no-no. Furthermore, she did all the testing and forensic results. And so, was it fair? No. Could you have an element of bias? Abso-bloody-lutely. Because remember, Sheree Colhane presented hair evidence that was used against Stephen in 1985. Sheree Colhane also did the pubic hair DNA extraction in 2003 that got him exonerated. If you want to be a cynical person, you can say that Sheree Colhane owed the state big time, and she delivered.
Yeah, it's worrisome. So in the field of DNA, so in the U.S. historically, it's been the FBI lab, and you'll see that even in this case, they've talked about the FBI standard for the number that you need, and that number has gone up from 15 to 20. I'm
20.
sorry, I don't know the exact numbers. And then in the UK, well, actually, all of the European Union, the Scotland Yard lab, the FBI lab was considered the gold standard until the National Institute report came out about a variety of things like matching hairs, fibers, fingerprints,
And teeth.
and it called into a question a number of things that the FBI was doing, and they were even trying to match bullets based on lead composition.
That's correct.
They actually testified in a few cases, and that was revealed to be total junk science.
White marks.
Who's the recognized leader in forensic DNA, Doc?
You mean who's assigned to do the testing?
Well, no, like it used to be FBI, but is it like Scotland Yard has got?
No, I believe it's still the FBI, because here's the problem that Kathleen Zona faces. She wants to use, and even I did the presentation on the MVAC and also rapid DNA testing. To my horror, they're not approved for crime scene analysis. Did you know that? They're not approved for crime scene analysis. I checked it the other day. Those techniques are so novel that they haven't been approved by the FBI. The FBI are looking into it. Kathleen Zona cannot utilize those results in a court of law because they haven't been recognized as tools for crime scene analysis.
That's crazy. That stuff is extensively used for identifying, victims from storms and fires and all kinds of things, and it works and it's repeatable, right?
Correct. But the argument is that something like MVAC is so sensitive, potentially it could cause mixed samples. And if you're not a person that knows how to handle that, then potentially you could get the wrong answer.
Sure.
So hence, MVAC is not approved for forensic crime scene analysis yet.
Yeah, so I do remember that. The affidavit of her expert that invented rapid DNA was, to test she asked for the bones that turned out were returned to the funeral home. But that person who invented that, he pointed out it was in numerous police departments and jails. They used it to positively identify people to determine, their identity. And so, very interesting that no one's been able to get that certified in a court of law yet. But
correct. And the beauty. Sorry.
No, I was just going to ask you, Doc, because it's been bugging me for a wee while. And this is to this one's for the panel and for people in chat. But Sherry Culhane she was on the case in 85, wasn't she?
Correct.
Oh yeah.
Right. So right. So that now this is bugging me even fucking more. Right. So she was on the case in 85. She put him away. She was on the case in 2003.
Correct.
That got him exonerated.
Yes.
Right. And then in 2005, she's on the case and he gets convicted again.
Correct. And
Now,
she volunteered. She put up her hand. She volunteered.
Yeah, she took the case.
Yeah, but as I've said before, Doc, I think she did that because she had some fucking making up to do because she got him out in 2003, right?
I believe
But
so.
my thing is, but my thing is in 2085, nobody was looking over her shoulder.
No,
In 2005, nobody was looking over her shoulder. So
they
could it be
yeah,
possible? Could it be possible that there was somebody over her shoulder from the Innocence Project or of that vicinity that was looking over her shoulder in 2003 when she found the hair and got the profile and said, oh no, it's Gregory Allen, it's not, you know,
No.
because I find it weird that 85 he's convicted, 2003 he's released, 2005 he's reconvicted again, and she also fucks up the protocol that she's never fucked up before. You know what I mean? So to me, I think somebody was over her shoulder or in the lab with her or something for her to get that that connection, that DNA result.
In
And then because
2003,
nobody was there in 2005, she done the same as what she done in 85.
Adam FL, Doc.
yeah, in
nucleated
1985,
cells.
in 1985, she basically stated that a hair that was found on Stephen's shirt resembled Penny Bernstein's hair, right? And it turned out to be absolute garbage, right? And that helped convict him. In 2003, Judge Hazelwood basically said, hey, if you don't get a result, I'm going to turn over the material to another laboratory to do the testing. So basically, Cherie Cohen was under intense pressure to get a result. And in actual fact, she did the test twice to make sure that the result was consistent. In 2005, when Buting and Strang took up the case, they said, look, we want to come into the crime lab and observe Cherie Cohen, what she does. The state rejected it. And of course, what had happened? Ida Mafel gets contaminated. The PCR negative control gets contaminated with Cherie Cohen's DNA.
Yeah. So to me,
Doc,
that's major sus, Doc. It's major sus. Sorry, Travis, on you go.
Yes, it is.
No, I was just going to mention, I know Doc said he's getting through Jerry Buting's book, but there was, and he even mentioned it in some of the pretrial arguments. He said, you know, Judge, I've run into problems in other counties. And he was talking about that case he got exonerated, and that prosecutor who he was able to show on purpose consumed a sample. But he had gotten an order in another county that any testing that the state was going to do, specifically the DA, they first had to notify Buting, and then Buting would have an opportunity to have his experts who were not him, not the attorney, but other DNA qualified experts, PhDs, to observe only what the lab was doing on this testing, because he knew there were problems. And so it goes to your point. I don't know if you're to that part of his book yet, Doc, but you know, he's very specific about what it turned out. And you know, that order, getting that order saved his client in the end. And the Supreme Court of Wisconsin, SCOW, ultimately said, no, this guy's going to get a new trial because of what the prosecutor did in combination with the lab. Now, I don't know, it was a different county that was involved clearly, and I don't know if it was the Wisconsin lab. I don't think it was, because I'm sure if it was Sherry Culhane in the Madison lab, he would have put that in his book. But, just to follow up on your point, Alice, is, I wanted to point that out. It's happened before in other cases, and it's why I think everybody will recall I commended everybody to reading his book. If you haven't read it, it sheds light on this particular case and some of the strategy decisions and whatnot. That was interesting, of course, but more interesting was this situation isn't isolated with Stephen's case. And you read about this man that he ended up getting exonerated. It was basically got him exonerated because of the misconduct of the DA, and then they ended up paying that man several $1 million. They settled it in a civil case, and it went up to the Seventh Circuit, the famous Seventh Circuit we all know and love. But the Seventh Circuit said, it was egregious what the DA did in terms of the testing of this very significant evidence that was fully consumed. So you can take that down, Jack, and maybe we can ask everybody if they have any questions about what we talked about tonight, or if we missed something that they posted earlier, and we can kind of catch those. And while anybody else on the panel has any more comments on this, we can see if there's any questions and or ones we've missed and go through those. If that's my suggestion. This is your all show, so I'm happy to do with whatever y'all want.
Sounds perfect, Travis. If there's any final questions that people want to ask, and then we can call it a wrap here in a few minutes, and then we'll do a part 4 when everybody is available.
I'm having a bit of a giggle here because the most common question throughout this entire podcast was asking about the bloody instrument, and I kept telling everyone, it's coming, slide 25, it's coming, and we're going to miss slide 25.
Yeah, we'll get it. We'll get it next time, Kel.
I was going to say, Travis.
Truly, and I promised that at the top of the show. I can't remember who asked that we're going to get to it, but really the bloody instrument probably deserves its own part, and that's the new evidence thing. And I will work with Jack and Kelly on that, and the three of us will do a PowerPoint on that together. How does that sound, Jack and Kelly, if we do that?
Yeah. Absolutely.
Yeah, I'm not phased at all. All good.
Kelly's already gotten me some stuff on it, but I'm, think we can do a thing on that. So I'm sorry to the person that asked at the very top of the show, and we promised we would get to it, and we'll do a separate one on that, and hopefully it's a time they can tune in.
They've been with us long enough, Travis, that they know that once we get started on one thing, then we can go off on a tangent on another, and then come back to what we were talking about, and then go back on another tangent. So it's all good. But rumour has it, in chat actually got quite a funny tale. She says that Rumour found out while reading Jerry's book that her sister lives in the same house in Madison where that murder took place that Jerry got the guy exonerated for. And her sister did not have a clue, and she phoned her immediately.
Oh, wow.
Wow.
Wow, that's wild. Yeah, that's amazing. But you know, as big as and diverse as Wisconsin is in terms of agriculture, industry, manufacturing, that as big as it is, there seems like there's always a connection, right? There's not a lot of separation there, but that's amazing.
It is. And that, for everybody wondering, that was the Armstrong case that Buting did. Ralph Armstrong. I have read Buting's book. I don't know if Doc is. We're actually doing Farrak's book right now, Travis, but I'm not sure if Doc and Nerley are planning on doing Illusions of Justice maybe at some point.
Yeah, I think we definitely have to look at that. No question.
But I think, aren't you actually kind of planning on heading into Greasebox books first?
Oh yeah, we need to look at Greaseback's book as well, because that goes into a lot of detail about what happened in 1985. But
right.
Let me just say, we've got a lot to go with Reading with the Crew.
Oh yeah, absolutely. Yep.
Well, I'm glad y'all are doing all of those, because you know it's going to be some time before this appeal works its way through, and then if she does get a evidentiary hearing, then one of the benefits is, you know, hopefully we'll have some educated guesses, so to speak, on what else she might be able to bring into it. The Veely CD, the pornography, the trying to hook more of the testing or retesting or new testing as part of that. And so we'll be in great shape for that in between, you know, the briefs getting filed and whatnot.
Absolutely.
Has anyone read any of the Kaczynski, not Lynn, Caccini? He's written a few books.
Yep, I have. I've read 2 of his books.
Are they worth the read? I haven't read those.
They're excellent books.
Yes.
Excellent.
Yes.
He's kind of like you, Travis. He has a really good way of explaining things in the layman's terms. You know, talking about what the actual term is, and then explaining what it really means to the court. They're really, really good books.
Yeah, because it's so easy. For example, we'll just toss out an example: procedural bar. And one of the things you mentioned to me initially, Jack, is, you know, there's kind of get just confusion on that, to where you know, at some point, based on what you hear, just having it read to you, that some people came away that the whole thing was denied because of procedural bar, or that anything she files, it's going to get denied because of procedural bar. Now, they may be right that no matter what she argues, it's going to get shot down for, you know, whatever reasons exist out there. But you know, hopefully at least now people know, yeah, some things were denied based on procedural bar, and then, you know, whose fault was that? They can conclude on their own. But some things were reached on the merits, and then, you know, here's the standards. But at least now, you know, it's not, well, you know, procedural bar, that rightly or wrongly, there were other reasons, and now we're back to real time, and people can look at was the circuit court just too restrictive in what she was requiring to show the three prongs? I think she was that, and people picked up on this on their own, but we were able to bring it back. Okay, here's the three-prong test. And, what the circuit court was saying by her examples, there's no defendant in the world that would be able to show those things other than coming up with DNA that was such a sort that, basically DNA that showed the real perpetrator. DNA that creates doubt, like from under the fingernails, wouldn't be good enough. But that's not what, is required under Denny, and, it's just an impossible standard. And so hopefully people now understand the difference between procedural bar and the three requirements under Denny: motive, opportunity, and direct connection. And I assume everybody disagrees with her rulings. I do on motive, opportunity, and direct connection. It's way too high, but I hope there's benefit of people knowing, well, it's not just procedural bar. She got over that, and then now that, they're throwing all of these other roadblocks in front of her. And, I think it's important that, it's more than procedural bar. And and hopefully it makes, when, the briefs are filed, hopefully it makes for a more informed reading of those briefs by people. Can't guarantee what the outcome's going to be, but, it's kind of like explaining Australian rules football to somebody, from when Richard and Stacey.
Don't go there, Travis. Don't go there.
Well, when Richard and Stacey went over to visit with Mark in Australia and see Nyrider and Drizzen at that presentation, one of the things, I'm pretty sure they went to an Australian rules football game. It may have been rugby, but but before you go to a cricket match or before you go to Australian rules football, it really helps a great deal if someone kind of explains the basics. Otherwise, you're just completely lost, and you're pretty much at the...
It doesn't help.
Yeah.
Even if you know the rules, it doesn't help.
Well, maybe poor analogy, but best I could come up with.
Yeah, Travis, not being just a guy looking at this from 50,000 feet, as Big Jeff says, I think that the bar that Judge Angie set for Kathleen it's impossible. There's absolutely no way she could ever reach that bar, ever.
Well, that's when Cal and I were getting prepared for it, and we were kind of going through these things, her arguments. We were laying out comments in Word, and I'm going, how on earth is somebody supposed to be able to prove this? It's supposed to be newly discovered, so there's not going to be any court records or phone calls or what have you. How can you conclusively show the circuit court that you're entitled to an evidentiary hearing, not a new trial, but just an evidentiary hearing? I started subscribing to the Wisconsin Law Journal. I don't know if I mentioned this, but they do informal polls and you have to be a Wisconsin bar member to vote in the poll. But they did a poll, and it got the most responses of other polls in recent history that I saw. But the question was asked, do you feel that Stephen Avery is entitled to an evidentiary hearing? Not a new trial, but an evidentiary hearing. And it was 80% versus 20% felt that he was entitled to a new evidentiary hearing.
Wow.
So this is Wisconsin lawyers, informal poll, but that's what the legal community, now it was, I think, 300 responded to that, which is, maybe 10% of the Wisconsin bar, maybe 5%. But, so prosecutors get that journal. They get the notice of the poll. Defense attorneys, civil, all attorneys. But so that was encouraging in one way and just kind of interesting. And then they took the poll down before the decision. I think around July, maybe August, I think they took the poll down. But at last count, 300 responses, 80% felt he deserved an evidentiary hearing.
That's interesting.
Very.
Okay. Yeah. Okay. Any more questions? I've been kind of trying to look here, Alice. I haven't seen any more questions in the chat, so this is probably a good time to do our.
Yeah, we're all good to wrap up, Jack. There's no more questions, but rumour has it has become a member for 5 months. Woo!
Nice.
Thank you, rumour. That's fantastic.
It is. All right, I'm just going to go down the list and give your final thoughts, and we'll do a wrap up. So, Alice, final thoughts.
Well, this has been brilliant. It's great having a legal on the channel, like Travis. So I'd like to say thank you to Travis, and thank you to Kel, for helping Travis put this together. It's been great, and I can't wait to see what part 4 is going to bring us. And just a quick reminder to people in chat, please remember that there has been a lot of questions for Travis coming in on the actual live chat and on our Discord and things like that. If your question hasn't been answered yet, but hopefully we have answered, because with the way Travis has set out his slides and things like that, he's answering quite a few things in one. So, but if your question hasn't been answered, please leave a comment underneath the video. Go to our Discord, leave a question in there, and I'm sure Travis will get to it. The ones that have been at the other 3 podcasts, just remember that your question will be there, and it'll be in the slides that Travis has prepared, because I noticed there was 50 odd slides and we've got to maybe 13 or something, so which is normal for us. So we will get there, like Kel says, when people were going on about the bloody object and things like that. We'll get there. It's coming. It will come. It definitely will come. But you've been with us long enough to know that once we get our teeth into something, we will go off on a tangent and we will talk about it, and then something else will come up. But you've been here long enough and you know that that's how it works on Foul Play. So thank you to everybody in chat. Thank you to everyone in panel. And I can't wait until the next one.
Thank you, Alice. Cherie, final thoughts.
Thank you for a very interesting and informative presentation and discussion. I really enjoyed it and learned a lot.
Thank you, Cherie. And then JD, you still here with us?
Yeah, I'm still here. So, yeah, I found it very informative. I still want to know what the answer is to that guy's question, though. So tune in for next time. But yeah, other than that, you know, you answered my little question about my DNA one and the entering into Coda, so I'm happy with everything that's come back. So onward and up.
Thank you so much, Jay, and thanks for staying up late as hell I know it's late for you, so much appreciated.
Well, I just hang out my washing on a washing line, right? It's 3 o'clock in the morning, and I thought, if I'm going to get up late in the morning, I ain't missing that sun, so I just raced in to catch you now.
Quite right, JD, quite right. We're getting a heat wave for a few days, so...
I know, I ain't missing that sun, that's why I stuck it out now.
And then we have Kel. Again, huge thanks to Kel and all the work. And people, you know, if you've done any research on your own, you understand when you start digging into finding things, you can get sucked off into a tangent. It's really difficult. So much appreciation, Kel. Final thoughts.
Oh, thank you. Yeah, I just want to say thanks for having me. It's awesome when I work with Trav, because it's funny because he's the one that installs the positivity in me. Here I am like, oh, it's all lost, it's all over, and Travis brings me back and goes, no, there's a way, and it's really encouraging to have someone that can guide us into looking at the other side. I pride myself in being balanced and trying to look at the other side, just so I do it, I think, personally, selfishly, just so I don't build myself up for disappointment and be prepared. But it's just really awesome to have someone in the community that has the experience, who's a lawyer, that can just, you know, remind us that, you know, it is a hard road. We are in post-conviction. We are in a place that has a potential dire outcome, but until that fat lady sings, it is not over. And this is what we're here for as a community, as a group, whether you're individually in researching or you're doing it in a group manner, everything matters. And I just want to thank you all again for allowing me to be here.
Absolutely. Thank you so much, Kel. And then we have a new person. Looks like they're named I don't know if they want to speak or not, but they're certainly welcome to. Okay, well, that's fine. You're more than welcome to just listen. And then Travis, any more final thoughts?
Thank you for having me. Thanks to Kelly for all her hard work. She makes these really and truly makes these so we can do them weekly. Without her help and hard, you know, on my own, it might take 2 to 3 weeks in between. Yeah, I like the way that I try and lay it all out in an outline to keep us on track, but you know, the whole thing of Discord, the philosophy and culture that I've seen, especially in the open mic, is that it encourages collaborations and discussions and respectful dialogue. And I think it's good that as we're talking, and it prompts a veer off a little ways and get back. Apologize that sometimes delays getting the answers to questions to people, but I really like the format. I'm looking very much forward to doing a presentation with at least Doc and Kelly on what the possibilities of a motion for scientific testing or DNA under 974, what that might look like, and maybe even what Kathleen, if she was given an evidentiary hearing by the Court of Appeals, what else she may be able to hook into that in that vein. I appreciate all of the nice comments, and it's good seeing friends in the chat that I've known for a long, long time, and JD will get you a good answer to your question. It'll be the top of the next part, I promise. But thank you, everybody, for your attention and listening in, and we'll just we'll KOB, right, Doc?
Yep.
Well, it is the adversarial process. And as I said at the beginning of the show, understanding how the court works, that's key. And, the expectation, and I think, not only for me, but Doc and, everybody at Foul Play, the open mic is exactly what you said, is to encourage civil debate and conversation, to prompt maybe something else. Hell, you never know. Like this, talking about this presentation for A23. That popped up tonight. That's fantastic. Anyway, so Doc, final thoughts?
Well, I must say, when I first turned on the podcast, I thought, how in the hell did Foul Play recruit Barry White?
Yeah, my voice is really screwed up.
No, all jokes aside, look, we're truly blessed to have the company of Travis and also the hard work of Kelly to put all this together and come on open mic and have an open format like this, and it's been fantastic. I must admit, I'm not very strong on the legal aspects of the case. My forte is in DNA, of course, but I really like the way Kelly and Travis has presented this in this format. I've learned a lot, and I'm learning a real lot. And it goes to show that even though you think you may have the answers, you got to present it in such a manner that a judge can hear it, understand it, and tip their hat towards you. And I know it's a long, complicated process. Again, guys, I want to thank Travis and Kelly for putting this on. We're truly honored. Thank you so much.
Thank you, Doc. And I couldn't agree more. Looking forward to the next one whenever that's available to do. Travis and Kel, we'll get it scheduled. It's not a problem, and we'll go from there. Big thanks to the live audience. And this is another part of this type of discussion. It's the serious side of understanding. I mean, it is to me. I don't know about everybody else, but I understand. I'm not a lawyer, but I do understand this adversarial process and the impact that it can have. So with that said, I want to thank everybody in the live chat for hanging around with us well, we've been going for about 4 hours, I think, right at it. Yep, just right after 4 hours. So we really appreciate it. And with that, I'm going to say this has been a Foul Play production.